The subcommittee will come to order. Without objection, the chair is authorized to declare a recess at any time. We welcome everyone here today for a joint hearing on judicial overreach in the federal courts. Before I recognize myself, I'd ask unanimous consent that members of the full committee, but not of the subcommittees, Mr. Moskowitz and Mr. Biggs, be allowed to sit in and participate in today's hearing. Without objection, so ordered. And as a point of personal privilege, before I make my opening statement, Speaker Gingrich, I've been here now, this is my 25th year on the Hill, and the first time I've had the pleasure of having you as a witness. I will cherish that as much as I cherish the time I once carried your bag off of an airplane in San Diego and found out you were the speaker, but you were also a regular guy. So with that, I'll now recognize myself for an opening statement. We are here today because a major malfunction in the federal judiciary has been recognized by both Republicans and Democrats. Activist district court judges usurping themselves with their Article III power and imposing on the nation injunctions beyond the scope of what the United States Congress under statute has given federal judges. These rogue judge rulings are a new resistance to the Trump administration and the only time in which judges in robes in this number have felt it necessary to participate in the political process rather than to participate in the Article III powers given to them both by the Constitution and by statute. President Trump was elected to assert many policies, including the deportation of criminal aliens. He did so publicly and was elected by a majority of Americans and the vast majority of the Electoral College. But he also did so in stark contrast to executive orders of the previous administration. Time and time again, rogue judges have asserted, as though they were 5 of the 9 members of the Supreme Court, their authority when the president was doing nothing more than undoing a policy of his predecessor, one which they seemed to have no problem with in the previous administration. Let me be clear, it should never have come to this. It is within the Supreme Court's ability to rule appropriately that judges have exceeded their jurisdiction. Time and time again, the High Court has ruled on the substance of the ruling rather than on the inappropriate nature of an injunction overly broad and affecting hundreds, thousands, or millions of people beyond the plaintiffs before that court. Just last night, a judge halted the administration's plan to end temporary protective status for about 350,000 Venezuelans that Joe Biden welcomed into this country and gave temporary protective status to. Temporary seems not to be a word understood by the court. If President Biden could give protective status temporarily, how, in fact, could it not be the prerogative of the next president to undo that status? Nowhere in that protective status was there an act of Congress or a recognition that temporary equals permanent. This is but the latest outrage coming from lower, or at least I might say the lowest courts. I have said from the start that my colleagues on the other side of the aisle should support this legislation. After all, it was the Biden administration who opposed these universal injunctions and said they were illegitimate. In fact, legislation in the last Congress, authored by a Democrat, is substantially similar to the one that we offer today and would have the same effect. To quote the previous administration's Solicitor General, literally the woman who spoke on behalf of the administration before the court, she said, "The government must prevail in every suit to keep its policy in force, but plaintiffs can derail a federal program nationwide with just one lower court victory," end quote. Those words by Elizabeth Prolongar, President Biden's own Solicitor General, were from October 2024. In other words, after almost the entire 4 years of the Biden administration, they still believed, and believed till the end, that this was wrong. And yet, we will probably hear today no support on the other side of the aisle. In fact, this is not new, but it is not old. For 180 years of our nation, there were no such injunctions. Only beginning in 1963 did district courts begin to, in relatively small amounts, believe that they could do these without multiple plaintiffs from multiple circuits. From 2001 to 2023, the number grew to 96. But an incredible 64 of those occurred during only 4 years, the 4 years of President Trump, meaning that more than half of all injunctions in this millennium, this century, were against President Trump in his first 4 years. That used to seem like a lot, but during President Trump's first 9 weeks in office this year, he has already faced more nationwide injunctions than President Joe Biden did in his entire 4 years. The federal judiciary isn't interpreting the law. It is impeding the presidency. It is, in fact, not co-equal, but holding itself to be superior. Since Marbury, Madison, there's no question at all that the third branch says it's the last word. And we have accepted that for over 200 years. But that acceptance is for the Supreme Court making a final decision, not one of over 700 district and appellate judges. The reality is every judge is considering himself not to be an associate justice, not to even be the Chief Justice, but in fact to be a combination of the justice and the President of the United States. This demands that we make a change and make it quickly. When a judge believes that he can order a full plane of criminal aliens back to U.S. soil, essentially saying that 200 years of a statute is to be overturned by his quick order without knowing even who was on the airplane. And finally, demanding that President Trump spend $2 billion in a single weekend, and I repeat, a weekend, and not tolerating any delay because that money was money that that judge believed should be spent, even if it was reckless and illegal. The last one might be understandable because a judge might have misunderstood and thought that President Biden was still in the White House, or that $2 billion, like the $188 billion that President Biden tried to forgive in student loans, and then, when thwarted by the United States Supreme Court, found a workaround that he believed was legitimate and gave away another $8 billion in loan forgiveness. No question at all, we had a rogue in the White House for 4 years. Many today will talk about the current occupant of the White House. But in fact, most of the rulings that are being overturned are simply undoing rogue activities of the previous administration. The No Rogues Ruling Act does not eliminate the ability of judges to make decisions. In fact, every decision made by a judge on behalf of a plaintiff would still go forward, but it would go forward only as to the plaintiff in front of him and not a nation as a whole determined by one judge, neither elected nor appointed to a position of sufficient power to speak on behalf of the entire nation. And with that, I would recognize the ranking member, Mr. Johnson, for his opening statement.
Thank you, Mr. Chairman, and thank you to the witnesses for your appearance today. Special shout out to former Speaker Newt Gingrich from the great state of Georgia. Professor Gingrich, good to see you. Of the many troubling actions the Trump administration has taken in its first 71 days, among the most damaging are his authoritarian, dictatorial, and unprecedented use of presidential power to instill fear, intimidate, exact revenge against, and punish those who dare to stand up to him and hold him accountable to the laws of our nation. A climate of fear and trepidation has descended upon the nation. The people of America are more afraid today for our democracy and for their personal safety than ever in our lifetimes. College students have disappeared off the streets paramilitary style by plainclothes, mask-wearing individuals and held incognito for days before they are discovered thousands of miles away in some private for-profit ICE detention facility. Why? For exercising their free speech First Amendment rights. Universities, bastions of free thought, have been punished for having the wrong ideology by having their federal funding revoked. And major law firms that dared to have brought cases against King Trump have been targeted with blatantly unconstitutional executive orders that, if allowed to stand, would shut those law firms down. Unfortunately, mega law firms Paul Weiss and Skadden Arps chose to settle with the king by pledging to represent pro bono only those persons and causes that the king approved of. Shame on them. Then there are other law firms that have stood up to King Trump, and they have challenged his executive orders against them in court, and they have won. Kudos to the lawyers at Perkins Coie, Covington and Burling, and Jenner and Block, among others, for standing up for themselves and for the rule of law and for our democracy. Although federal courts have consistently ruled against these numerous unconstitutional executive orders of President Trump, the mere existence of these retaliatory executive orders should be chilling to all of us. There has been no semblance of due process or fairness in any of these cases. Trump acts first, he deports first, he revokes funding first, he blacklists law firms first, and then questions anyone who challenges him later. Somehow, in spite of this, we are here today to talk about the, quote, overreach, end quote, of the federal courts, not the overreach of the executive branch official who is doing the overreaching. Our Republican colleagues want us to believe that simply because the courts are exercising their Article III power of equitable relief to temporarily halt some of Trump's most excessive executive actions, it is a sign of rot in our judicial system, that it is somehow our courts and judges, not the president, who have gone rogue and are overreaching. I disagree, but more importantly, so do the numbers. Since day one of his second term, Trump has attempted to rework our constitutional system of government through presidential fiat, issuing a record 107 executive orders in his first 71 days in office. As I mentioned, many of these executive orders are unlawful or unconstitutional, and the president does not have the power to change the Constitution through executive order, even if his name is Donald Trump. Naturally, they have been challenged in court, and of the over 150 cases filed against the Trump administration, judges have ruled against him 46 times. Of those 46, only 17 are nationwide injunctions. The cases are spread across district courts throughout the country, and judges appointed by Democrat and Republican presidents have all ruled against Donald Trump. What we are seeing playing out in courts across the country today is the judicial system working exactly as it should. America's federal courts have been handed case after case, challenging executive orders standing on questionable legal footing. And yet, the proportionally small number of nationwide injunctions shows the restraint exhibited by the judges considering those cases. I don't know what Donald Trump thought would happen when the cases made their way to the judicial branch, but clearly he has had enough with losing in court. Instead of letting the rule of law play out, Trump and his allies here in Congress now have chosen to go on the attack. Trump and his cronies have called federal judges rogue and corrupt. A judge it was suggested that a judge supports terrorists, and they've called judicial rulings judicial coups. MAGA Republicans in Congress have called for judges to be impeached, not because they committed a high crime or misdemeanor, but simply because they ruled against Trump. And far-right media personalities have attacked the judges' families, publicizing their personal information for millions of their riled-up followers on social media. What I had just described is nothing less than a full-scale assault on our entire judicial system, and it is putting judges, their family, and their staff lives at risk. We don't agree on much on this committee, but we should be able to agree that this is wrong, and we should be able to agree to back away from language demonizing the judicial branch, no matter what political party we belong to. Today's hearing is not just about helping Donald Trump undermine the judicial branch, though, well, let me say that this hearing is not just about helping Donald Trump undermine the judicial branch, though certainly it is about that. But Republicans on this committee are sending a message to anyone who dares to stand up to Donald Trump. If you step out of line, they will target you next. We cannot afford to allow what Donald Trump is doing through retaliatory executive orders, through targeting immigrants, through threatening lawyers, through vilifying judges, to become the normal. Our Constitution is being tested, and throughout American history, it has stood up to attempts to weaken its protections. Americans across the country are watching, and they know they didn't vote for Trump to destroy our democracy. They voted for Trump because he promised to lower the cost of living, and Trump has betrayed their trust. Prices are going up, and our economy is headed towards recession as co-President Musk threatens to take away people's Social Security, Medicaid, Medicare, SNAP benefits, and veterans care. Trump is doing nothing to deliver on the promises to the American people. I stand with my fellow Americans, with the federal judges who continue to bravely do their jobs in the face of criticism, and I yield back.
I now recognize the chairman of the Subcommittee on the Constitution and Limited Government, Mr. Roy, for his opening statement.
I want to thank the gentleman from California and my co-chairman on this hearing. It's an important hearing. I thank him for his work on this issue as well as his legislation addressing the matter. And I'd like to welcome the guests who are joining us here today. Appreciate your time, obviously, particularly you, Mr. Speaker, and your great service to this country, and great to have your expertise here. We thank you. And I also want to give a shout out to Cindy Romero. I met Ms. Romero last August in Aurora, Colorado, and I appreciate what she's going to be here to testify about today and her great service. So with that, I would like to take a slightly different angle as the chairman of the Subcommittee on the Constitution than the direction that my friend from California took, because I want to emphasize the judicial overreach we've witnessed over the last 2 months and nationwide injunctions more broadly that are undermining the constitutional structure our founders so wisely envisioned. The nature of the executive branch was a primary point of contention at the Constitutional Convention. Some delegates favored a plural executive, thinking that this arrangement would better preserve liberty. But they were wrong, and our founders wisely resisted their calls. Instead, the Constitution lodges the executive power in a single President of the United States. Alexander Hamilton offered the classic defense of this arrangement in Federalist 70, emphasizing that a vigorous and energetic executive is necessary to defend our liberty from foreign threats. Hamilton rightly argued that unity in the executive was the essential ingredient in this formula. Only a single executive could act with the decision, activity, secrecy, and dispatch necessary to adequately carry out the office. And on a note, I have introduced legislation in the past, it's called the Article 1 Act, to try to cabin in the executive branch when it's not necessarily working directly with Congress, and I'm happy to work with my colleagues on the other side of the aisle on these concepts when we have these lingering emergencies, in many cases these national emergencies that date back to the 1970s. There are times for the Congress and for the legislative branch to assert itself. But the president's authority is at its zenith when we're talking about his actions as commander-in-chief. Injunctions and temporary restraining orders halting presidential actions nationwide threaten the key feature of our constitutional architecture, undermining the core premise of unity in the executive branch, the unitary executive, as we refer to it. Even the most strident proponents of a plural executive at the Constitutional Convention advocated for an executive council of 3, maybe 5 members. Today, in practice, we are governed by an executive council of 678. The nationally elected president and 677 district court judges, each of whom retains a functional veto over executive actions through their power to issue nationwide injunctions. Scholars have long understood that a hostile judiciary, or even a single hostile judge, could abuse its power to issue nationwide injunctions to infringe upon the lawful authority of the President of the United States. Now, that's not a partisan point. I've got numerous examples of our colleagues on the other side of the aisle who have raised these concerns. The Biden administration's Solicitor General, Elizabeth Prelogar, told the Supreme Court as recently as 2024 that, quote, a court of equity may grant relief only to the parties before it. The district court violated that principle by issuing a nationwide injunction, ... In 2022, Solicitor General Prelogar asked the Supreme Court to address nationwide injunctions as permissible relief in United States versus Texas, arguing that district courts normally, quote, should only provide relief for the benefit of the prevailing challenger. What happened there was our Democratic colleagues started realizing that when Republicans went to district courts to get injunctions against their president, that suddenly they didn't like it so much. So they were raising concerns. Justice Elena Kagan spoke out against nationwide injunctions by a single district judge in 22, quote, the ability of a single judge to stop implementation of a policy across the country. She stated, in the Trump years, people used to go to the Northern District of California, and in the Biden years, they go to Texas. Just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for the years that it takes to go through the normal process. Former United States Rep. Mondaire Jones introduced the Injunction Reform Act in 2022. I could go through the quotes that he offered, but I won't. I can offer those for the record without objection. In a letter to William Torrance dated June 11th, 1815, Thomas Jefferson explained who decides constitutional questions. Certainly, there is not a word in the Constitution which has given judges that power, authority to decide on the constitutionality of a law more than to the executive or legislative branches, meaning we all have an obligation and a role to do that. Questions of property, of character, and of crime being ascribed to the judges through a definite course of legal proceedings, laws involving such questions belong, of course, to them in the judiciary. And as they decide on them, ultimately and without appeal, they, of course, decide for themselves the constitutional validity of the law. In other words, our founders never intended the federal courts to have the ability to unilaterally decide constitutional questions, as these judges are unelected and were never given the power to legislate from the bench. Treating the courts as the final authority on public policy, grants them more power than even Madison's rejected Council of Revision proposal at the Constitutional Convention. Indeed, it happened regularly during the first Trump administration, as we've pointed out. Now in the second Trump administration, it is on steroids. As of last week, district courts had issued no fewer than 17 nationwide injunctions against administrative actions, with scores more temporary restraining orders, or TROs as we call them, as barring the president from enacting the agenda upon which he was elected. Alexander Hamilton wrote in Federalist 78 that even the Supreme Court would wield neither force nor will over politics, indicating he never envisioned the judiciary having the final say on every political decision or action. Now these injunctions and TROs have even infringed upon what the Supreme Court has described as conclusive and preclusive presidential powers, including core presidential authorities to conduct foreign affairs and repel invasions. Now, I have got numerous examples of what we've been dealing with. Just so people know, this is a 56-page summary that I've got of the 158, it might be 159 now, because we're having to track them on a daily basis, lawsuits against the administration and against the president for carrying out the agenda upon which he was elected. 17 injunctions, I think there are a great number more TROs, and the cases we're talking about, without going through all of them, nationwide TRO enjoining the Trump administration from freezing foreign assistance funding, enforcement order requiring the administration to pay approximately $2 billion within 36 hours. That's a judge singularly acting against the president's actions. Another one, provisionally certifying a class and enjoining the Trump administration from deporting members of a foreign terrorist organization. A nationwide injunction enjoining the Trump administration from pausing, terminating, or amending any equity-related grants or contracts, DEI. A nationwide injunction enjoining the Trump administration from prohibiting federal funds from being spent to promote gender ideology. A nationwide TRO enjoining the Trump administration from prohibiting biological men from being housed in women's prisons. 2 injunctions regarding the administration for implementing an executive order considering transgender individuals in the military, birthright citizenship, issue after issue after issue that the administration is trying to act on according to the campaign upon which he ran. One in particular has earned the scrutiny it has received. Just 2 weeks ago, Judge Boasberg of the District Court of the District of Columbia ordered the administration to stop the deportation of members of Tren de Aragua, a violent Venezuelan gang that has terrorized cities and towns across the country. At this table, in this room, we heard testimony from Alexis Nungare, whose daughter Jocelyn was murdered by TDA in the suburbs of Houston. Right here, we heard her powerful testimony about what that gang has done to this country. We're going to hear from Ms. Romero today about what that gang did to her community in Aurora, Colorado. And here we have a single district judge who's asserting jurisdiction from the District of Columbia to tell the President of the United States that he cannot deport members of the violent TDA gang out of this country to keep our streets safe. That is not what is supposed to occur. Today's hearing, where we'll learn from constitutional scholars and real Americans about what is wrong with the current system, is a good start. We should carefully study whether Congress should push back against judicial overreach using its constitutional power to structure and fund the courts. Our Constitution did not create a plural executive or judicial tyranny. Today, we're far too close to both. With that, I yield back.
The gentleman yields back. We'll now recognize the subcommittee ranking member for her opening statements, Ms. Scanlon.
Thank you. Like the chairman of the subcommittee on the Constitution, as ranking member, I too would like to address the constitutional concerns raised by this hearing. Our Republican colleagues have called this hearing today for one reason, because this White House, this president, continues to lose over and over again in court. As people and groups from across the political spectrum challenge the barrage of unconstitutional and illegal executive actions taken by this White House in just the first few weeks of this term. Because it doesn't matter if the judges were appointed by Bush or Biden or Obama or Reagan or by Trump himself. When the president attempts illegal or unconstitutional actions, United States judges, guided by the letter of the law, must rule against him. It's a confirmation of the total subservience of today's Republican Party to this president that their response to multiple judicial rulings of executive overreach is a hearing entitled Judicial Overreach and Constitutional Limits on Federal Courts, when we should be holding a hearing on presidential power grabs and constitutional limits on executive power. This is Civics 101. The Constitution provides in Article 1 that Congress writes the laws. In Article 2, the President administers the laws. And in Article 3, the courts interpret the laws. Our Republican colleagues are concerned about the unprecedented number of successful lawsuits challenging this president's executive overreach. But it's not the actions of the courts in interpreting our Constitution and laws that are unprecedented. It's the scope and breadth of this president's executive orders that are unprecedented. It's this president's attempt to go it alone, to usurp the power of Congress and we the people, to rewrite the laws of this country and the Constitution, and to reserve unto himself, rather than the judiciary, the right to interpret the laws and our Constitution. The sheer volume of unconstitutional and illegal actions taken by this president in just the first few weeks of his term has led some to wonder if the president fundamentally misunderstands the nature and terms of his Article 2 powers. Specifically, when Article 2, Section 3 says that the president shall take care to faithfully execute the laws passed by Congress, does this president think that the word execute means that he's supposed to kill laws rather than carry them out? Unfortunately, the underlying rationale for much of this action is a radical theory set forth in Project 2025 and elsewhere. It's one that would vest federal power in a unitary executive, sidelining two of the three co-equal branches of our government, Congress and the judiciary. We're here because Republicans who control the House and Senate have, thus far, chosen to abandon their constitutional duty to constrain an out-of-control executive branch. If they don't see anything wrong with it, their constituents do, and more of our colleagues would know that if they actually showed up at town halls in their districts. Our Constitution is built upon the rule of law, that no one is above the law, and our legal system is built on the idea of judicial independence. In the past 2 months, we've seen our judicial system working as the founders intended, and as the Supreme Court ruled in Madison versus Marbury over 200 years ago, it's the job of our judiciary to declare laws and executive actions unconstitutional if they're in conflict with the Constitution. The federal judges who've ruled against President Trump's unlawful power grabs are simply interpreting the Constitution and the laws passed by Congress to protect the rights of the American people. To suggest otherwise is to substitute a theory of executive primacy that is completely at odds with our constitutional history and separation of powers. Mr. Chairman, I wish that we could dismiss today's hearing as just political theory or theater, but the stakes are too high for the American people and their rights hang in the balance. While this administration has begun by attacking people it vilifies, including immigrants, students, or working people, no one should kid themselves. It's clear the rights of every American are at stake. When the White House and some of our colleagues claim the right to deny due process to immigrants who they claim have broken a law, that's a sham. Because if you don't support the rights of immigrants to due process, then you don't support anyone's right to due process. Because without due process, the government can do whatever it wants to anyone, including citizens, and they aren't able to defend themselves. What's to stop ICE from saying that Mr. Roy or Mr. Jordan is a member of a violent gang and shipping them out of the country? Attacks on our courts, whether in the form of executive orders punishing law firms and lawyers that dare to stand up for the rule of law, or hearings like this attempting to constrain the courts, or tweets urging impeachment or violence against judges, are part of a broader attack on the rule of law. Our Republican colleagues have shown that they're not concerned about civil rights and the rule of law. Their sole concern appears to be whether or not a federal judge has ruled against this administration. They've gone so far as to call for impeaching judges who rule against this White House, eliminating courts altogether, or advocating to cut off funding for the court system. The fact is, if the president wants to end his legal woes, he can simply follow the Constitution and our laws. Because if a president issues illegal executive orders, the courts are duty-bound to block them. But rather than accepting that reality, our Republican colleagues would rather hand the president the keys to unchecked authoritarian power. Let's be real. Americans elect a president every 4 years, not a king. Even if President Trump had won a landslide electoral victory, which he didn't, that would be beside the point. An electoral victory does not justify running roughshod over the courts and the Constitution, which every president is sworn to uphold. Presidential power is not absolute. When President Trump empowers Elon Musk to ignore laws Congress passed or slash funding Congress appropriated, he's undermining the power of the American people who voted us into office. If President Trump's agenda is as popular as he claims, he can work with his allies in Congress to convince the American people to support it. But he has no right to simply do whatever he wants just because House and Senate Republicans don't have the backbone to stop him. Democrats and independents are standing up against President Trump's blatant power grabs because if he can deny the rights of some people, There's nothing stopping him from denying the rights of all people all across America. And that should concern everyone in this room and everyone across this nation. I yield back.
Gentlelady yields back. We now recognize the chairman of the full committee for his opening statement, Mr. Jordan.
Thank you, Mr. Chairman. Who decides? That's the fundamental question. Who gets to make the call? Is it the guy whose name was on the ballot, or is it some bureaucrat? Is it the guy who got 77 million votes, or some district judge? The left always says, trust the bureaucrat, trust the judge. It's the Faucis, it's the Boasbergs who get to make the call. After all, they're the experts. They're smarter than we, the people. They're smarter than all us hillbillies in flyover country who voted for President Trump. Trust them. That's not how it works. We, the people, have the power. You know what's interesting? For all the left's talk about democracy, they don't really trust it. Last summer, they kicked their nominee off the ballot without a vote, without an election, and they put someone else on the ballot without a vote, without an election. So of course they like some judge issuing orders or injunctions that stop the head of the executive branch from doing what he said he was going to do when he ran for the job and when the American people elected him. Think about it. Here in D.C., an elected judge thinks she's better equipped to determine military readiness than the commander-in-chief. An unelected judge in California thinks he gets to decide how many probationary employees work in the executive branch, not the guy who was elected to run the executive branch. Another unelected federal district judge here in D.C. thinks he gets to decide how long illegal gang member terrorists stay in our country, not the president, not the commander-in-chief. And now that same judge gets randomly assigned the Hexeth case, and he'll get to determine who the Secretary of Defense can talk to and how he has to do it, not the president. I think Americans see through this all. They know Representative Iss's legislation is exactly what's needed. They know who they elected, and they want him to make decisions that affect the executive branch, that affect our country. So I want to thank our chairman, Mr. Issa and Mr. Roy, for this hearing. I want to thank Mr. Issa for his bill. Mr. Schmidt, a member of our committee, who we put an amendment, his amendment on that bill, which I think makes it even stronger. We passed that legislation 4 weeks ago. It's going to be on the floor tomorrow. It's going to pass the House. I want to thank our witnesses for being here. Ms. Romero, what you've went through, thank you for coming. And of course, Speaker Gingrich, for your half a century of service to the Constitution and the country, thank you for joining us. That is the question, though. Who decides? The individuals that we, the people, elect, or someone else? I yield back.
Gentleman yields back. We now recognize the ranking member of the full committee, the gentleman from Maryland, Mr. Raskin.
Thank you very much, Mr. Chairman, and thanks to our witnesses for joining us today. So why have 34 federal judges from 11 different districts with a combined 474 years of service on the bench, judges appointed by Presidents Reagan, Bush, Clinton, Bush, Obama, and Trump, entered 57 different preliminary injunctions and temporary restraining orders against President Trump and Elon Musk's executive orders and actions, like the ones nullifying constitutional birthright citizenship, unilaterally dismantling congressionally created agencies, or impounding and diverting funds appropriated by Congress. Well, the majority says it's because these are radical judges. And they lead off, as our good Chairman Issa did, with Judge Jeb Boasberg, the chief judge of the District Court of the District of Columbia, who enjoined the mass roundup and deportation of immigrants to an infamous El Salvadoran prison in peacetime without any due process at all, allegedly under the Alien Enemies Act of 1798, a statute explicitly limited to wartime and military invasion. Some of our colleagues have been railing against Judge Boasberg for ordering the planes to be turned around. They say those planes were filled with terrorists, I think my good friend from Texas said. Well, here's one person of many who wasn't a terrorist on that flight or a gangbanger. His name's Kilmer Garcia. He's a Marylander married to a U.S. citizen who has a 5-year-old son with autism. And he went to pick up his son, but he was picked up first by ICE. And then he was shackled and put on that airplane and shipped off to the torturers of El Salvador without ever having the benefit of those two most beautiful words in the English language, due process. He never saw a judge. Nobody ever told him what he was being charged for. Nobody ever told him that there were any charges against him. And he was sent to a mega prison run by the self-proclaimed dictator of El Salvador. And yesterday, you know what happened, Mr. Chairman? The Trump administration admitted that it had made a mistake. He was not actually a gangbanger. He was not a criminal. It was all a mistake. If there'd been due process, maybe that would have been determined, but there wasn't. But they put him on that plane and he's El Salvador. Well, all's well that ends well, right? No. The administration says there's nothing they can do about it now because he's no longer in U.S. custody. This guy who lives in my state, married to a U.S. citizen with citizen children, he's stuck with the dictator of El Salvador. Well, Judge Boasberg, some of our colleagues want to impeach him. Look, some of our colleagues, they've got "for wanted" signs in the Cannon House office building with the names and faces of judges on them. They want to impeach them now. They want to impeach Judge Boasberg. Some of my colleagues should be alerted to this fact. Judge Boasberg was first named to the bench by President Bush. He was Justice Kavanaugh's roommate at Yale. Known in legal quarters as a very conservative judge, but they want to impeach him because he stood up for the rule of law. Now, Democrats say all of these executive orders and actions are being struck down not because these are radical left rogue judges, but because the judges, regardless of who appointed them, are doing their jobs. If the number of decisions striking down Trump illegality is unprecedented today, it's only because the sheer number of illegal acts committed in the first 100 days is unprecedented. America's never seen anything like it before in our entire history. Trump and Musk have been systematically violating the Constitution and breaking the law to trample the rights of the people and steal our data, fire excellent federal workers en masse, and dismantle congressionally created government agencies and programs, from the VA and Medicaid to NOAA, NIH, and Social Security, which Elon Musk called, quote, the biggest Ponzi scheme of all time. When brave Americans go to court to defend themselves against the President of the United States and the richest man in the world, these judges from across the political spectrum are showing up to work, and they're showing America why we have an independent judiciary. And yes, I've got to tell my friend Chairman Jordan that even if you campaign on doing something unconstitutional, like naming people kings and queens, or stealing other people's money, no, that doesn't make it constitutional, even if you campaigned on it. And the vast majority of the things here, I never heard of them campaigning on. But in any event, it's irrelevant to the job of the courts. Anyone who's read any of the decisions knows that what we're witnessing today is a matchless constitutional crime spree by a rogue president and his Doge enforcer, a government contractor who has pocketed $38 billion from the taxpayers, multiples more than he has ever even claimed to have saved us. And we know how Doge makes typos, converting millions into billions. Read the decisions. Look at these cases, finding that Trump violated Congress's spending power and usurped our lawmaking power under Article 1. Read the cases, finding that Trump violated the First Amendment free speech rights, the Fifth Amendment due process rights, the Sixth Amendment counsel rights of the people, even by discriminating by name against law firms and lawyers, actually banning specific firms and lawyers from federal buildings and courthouses, federal contracts and federal employment, all simply because they dared to represent their clients, and Trump hates them. Now, out of this mountain of cases, which I can only surmise our colleagues have not read, let's zero in on Trump's executive order contradicting the very first sentence of the 14th Amendment, which says that any person born or naturalized in the United States and subject to the jurisdiction thereof is a citizen of the United States. Trump got struck down by a Reagan judge, a Biden judge, an Obama judge, and a Bush judge. The Reagan judge said, quote, "I've been on the bench for 4 decades. I can't remember another case where the question presented is as clear as this one. This is a blatantly unconstitutional order." Blatantly. This is from a Reagan judge. Now, my colleagues seem to think that an executive order is greater than a law or the Constitution itself. But an executive order cannot trump a federal statute, much less the Constitution. An executive order is just an order to the executive bureaucracy to follow a policy unless and until it's countermanded by law, by the courts. Many of our colleagues are following Trump and Musk in calling for impeachment right now. There have been only 15 federal judges impeached in all of American history, always for serious professional misconduct, like taking bribes, stealing from the court, or habitual drunkenness, not even occasional drunkenness, habitual drunkenness on the bench. Congress has never defined a doctrinal or interpretive disagreement as a high crime and misdemeanor, much less when the judge's reasoning was airtight correct. The spreading movement to impeach and attack judges is so alarming that Chief Justice Roberts issued a rare statement last week. He said, for more than 2 centuries, it's been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. The proper response, of course, is to appeal the decision. And to be fair, Chairman Issa expressed his strong disapproval of these wanted posters yesterday in the Rules Committee. Now, for some members, talk of impeaching these so-called rogue judges is just fun and games. But the vicious assault, the vicious rhetorical assault on the judiciary has turned into something more sinister in certain quarters. Actual violent threats, bomb threats, direct intimidation. Judge Boasberg, the Bush appointee, must endure scandalous online attacks and insults by President Trump and Elon Musk and their followers. Even worse, the campaign of vilification has spread to Judge Boasberg's family, including outrageous attacks on his daughter, who's had her photo and her place of work posted on social media by Elon Musk to his 290 million followers. These threats follow an actual bomb threat made to the sister of Supreme Court Justice Amy Coney Barrett. And there are numerous other threats taking place today. And of course, we've seen threats and actual violence and murders take place in the past. I call on my colleagues right now to call off the campaign to impeach federal judges for doing their jobs. I call on them to demand that the Trump administration comply with all judicial orders while appealing whichever ones they want to appeal, and to demand the return of people unlawfully taken to El Salvador on that so-called plane full of gangbangers. And I especially call on them today to denounce all violent threats, doxing, online vilification, and threats against our judges. This is the Judiciary Committee of the United States House of Representatives, and we should act like it. I yield back, Mr. Chairman.
I thank the gentleman. I ask unanimous consent that the official statement by ICE officials agreeing that there was not 100% accuracy in Mr. Garcia's arrest, that in fact he was a prominent member of MS-13, a different recognized terrorist group. Without objection, so ordered. Without objection, all other opening statements will be included in the record. I'd now like to introduce our distinguished panel, beginning with the Honorable Newt Gingrich. Mr. Gingrich is the former colleague here in the House and served from 1979 to 1999, including 4 years as the Speaker of the House. Speaker Gingrich was instrumental in formulating Contract with America and returning Republicans to a House majority after 40 years of Democrat control. Since leaving the Congress, he has remained incredibly active, and in fact, in both policy, politics, and government, he has led, having authored several dozen books and teaching military officers and other national security professionals at the National Defense University. Welcome, Mr. Speaker. Mr. Paul Larkin. Mr. Larkin is the John Barbara and Victoria Rumpel Senior Legal Research Fellow at the Edwin Meese III Center for Legal and Judicial Studies at Heritage Foundation. Before joining Heritage, Mr. Larkin served in various positions in the Department of Justice and at the EPA, and as a Senate staff. He has spent a number of years in private practice and is most prepared for today's hearing. Welcome. Ms. Cindy Romero. Ms. Romero is a resident of Aurora, Colorado, who saw firsthand the effects of soft on crime and open border immigration policy. She was a resident of an apartment complex targeted by Tren de Agua and eventually was forced to move after her neighbors were reportedly victimized and her car was struck by gunfire. Lastly, Professor Kate Shaw. Ms. Shaw is a professor of law at the University of Pennsylvania, Carey Law School. Professor Shaw focuses on executive power and the Supreme Court, along with other issues. I want to welcome all of our witnesses and ask that you please rise to take the pledge to be sworn in. The right hand. Do you solemnly swear or affirm under penalty of perjury that the testimony you're about to give will be the truth and correct to the best of your knowledge, information, and belief, so help you God? Please be seated. Let the record reflect that all witnesses answered in the affirmative. We'll begin with Mr. Larkin, and I would only ask, you've all seen this on C-SPAN, but to the greatest extent possible, please wrap up by the end of 5 minutes. You'll have the indicator on your desk, but your entire statements will be included in the record, as will additional information, which I can't speak for everyone, but I know the speaker will revise and extend with considerable authentication. Mr. Larkin. I think check and make sure you're on and pull it a little closer, perhaps.
Is that better?
Much.
The practice of issuing nationwide injunctions outside the confines of a certified nationwide class action is mistaken as a matter of law and unwise as a matter of policy. Let's start with the law, and in there, let's also start with the Constitution. The legislative power is granted to Congress. And what is the primary product of that legislative power? It is what the Constitution defines as a law. The term law also shows up in Article 3, but it shows up in Article 3 under the phrase arising under the Constitution, the laws, or treaties. It is not the courts that are responsible for creating the law. It's the courts who are responsible for interpreting it as it applies. But they can only do so in the context of a case or controversy, two structural limitations on what the courts can do. In other words, in order for the courts to be able to say what the law is, they have to get on the playing field, and in order to do that, you have to have a case or controversy. Now, why does that matter? Well, the Constitution does speak to this. As I've said, only the Congress can create a law. Anytime a court enters a judgment that is tantamount to being a law, the judge has gone too far. And in the case of nationwide injunctions, a judgment in favor of non-parties goes too far. You also have no statute in the Judicial Code, no provision in the Constitution, and no settled history at common law that allows a judge to enter these sorts of orders. That's important because everything has to fit into one of those three. Why? The Supreme Court has interpreted Article 3 in light of how it was understood in 1789. And so those are the three primary bases that you have to look to: the text of the Constitution, statutes, and English common law history. In fact, there are two Supreme Court cases that directly undermine the legitimacy of nationwide injunctions outside of certified class actions. One is Williams versus Zabarez. In that case, the court said there is no case or controversy between two parties that are in a case over an issue that has not been put into dispute by one or the other of them. It logically follows that there is no issue in dispute between someone who is a party and someone who is a stranger to the entire litigation. Similarly, at the back end of the process is the case of United States versus Mendoza, where the Supreme Court held that the federal government is not subject to the win or go home rule that you see in the NCAA postseason tournament. The government isn't stuck with whatever loss it has the first time it litigates a case to a final judgment and loses. The doctrines in the law of issue preclusion or collateral estoppel, the new and old terms, do not apply to the federal government. Why? The Supreme Court, in a unanimous decision in Mendoza, said they do not. Why? Because there are a variety of good policy reasons why it shouldn't. With that, then let me turn to the policy reasons that show this practice is unwise. There are several, okay? First, mandatory injunctions prevent the percolation of issues in the lower court that the U.S. Supreme Court in Mendoza said is necessary for that court to be able best to resolve whatever legal dispute there is. It allows the court to be sure that all of the issues, all of the sub-issues, all of the arguments pro and con, all of the benefits and costs of whatever rule are fully aired. Secondly, it encourages judge shopping. All you have to do is find one favorable judge, and you can stop an entire administration in its tracks. And as you know, it has happened to every administration over the course of this 21st century, from the George W. Bush administration to the present. Each party has been subject to this practice. Third, it can result in conflicting nationwide judgments. You can wind up with injunctions going one way and the other way because a court in Maine and a court in Alaska can come out the opposite way in a case. Finally, they are going to weaken the doctrine of stare decisis, because as the Supreme Court comes to realize, if it has to decide issues at a preliminary stage of the case without the guidance of the lower courts, they're going to have to overrule some of their decisions. Let me end where I began. This practice is mistaken as a matter of law and unwise as a matter of policy. Thank you.
Thank you. Speaker Gingrich.
Thank you, Chairman Issa and Roy, Ranking Members Johnson and Scanlon, and all the members of the subcommittees for allowing me to testify. There is clearly a potential constitutional crisis involving the judicial branch's effort to fully override the legislative and executive branches. 15 district judges effectively seized control of various executive branch duties in the first 6 weeks of the current presidency through nationwide injunctions. This is potentially a judicial coup d'etat. It clearly violates the Constitution and more than 200 years of American history. To set the stage for this hearing, let me mention 12 former federal judges appointed by President John Adams: Richard Bassett, Egbert Benson, Benjamin Bourne, William Griffith, Samuel Hitchcock, Philip Barton Kay, Jeremiah Smith, George Keith Taylor, Oliver Wilcott Jr., Williams McClung, Charles McGill, and Williams Tillman. President Adams appointed these federal judges on his way out of office to hamstring the incoming President Thomas Jefferson's agenda. President Jefferson concluded that impeaching the judges would take too much time. He and the Congress simply abolished the courts in which they served via the Judiciary Act of 1802. This is a constitutional balance of power. The legislative and executive branches can reshape the judiciary branch. It is a useful reminder in considering the current situation. Unelected lower court judges have been steadily grabbing power for years. It was such an obvious threat that in 2012, Vince Haley and I wrote, "Bringing the Court Back Under the Constitution." It is an historic study which I am submitting for the record. According to Harvard Law Review, there were 96 nationwide injunctions ordered by district courts from 2001 to 2023. Two-thirds of them, 64, were issued during President's time in office. Furthermore, 92% of the injunctions against President Trump were issued by judges appointed by Democratic presidents. Since January 20th, 2025, lower courts have imposed 15 nationwide injunctions against the current Trump administration. This is compared to 6 during George W. Bush's 8 years, 12 during Barack Obama's 8 years, and 14 during Joe Biden's 4-year term. The notion that unelected lawyers can micromanage the executive branch and override a commander-in-chief who received 77.3 million votes should trouble every American. This is particularly troubling for issues of national defense and public safety. Around 500 BC, Sun Tzu asserted in The Art of War that, quote, "Speed is the essence of war." How can the United States have speed in national security issues if opponents can judge shop to find someone ambitious or arrogant enough to block, repudiate, or delay the president's decisions? There are 677 authorized district judgeships. How many think they can override duly elected presidents? This summary statement has 4 propositions. First, the courts have often been challenged. President Jefferson wrote, quote, "Judges as the ultimate arbiters of all constitutional questions would place us under the despotism of an oligarchy," close quote. President Andrew Jackson was in constant fights with the Supreme Court. President Abraham Lincoln made the Dred Scott decision expanding slavery a centerpiece of his 1858 senatorial campaign. In his first inaugural, President Lincoln warned that if the Supreme Court held supreme rule, quote, "the people will have ceased to be their own rulers, having to that extent practically resigned their government into the hands of that eminent tribunal," close quote. Second, as the Judiciary Act of 1802 proves, the legislative and executive branches can constitutionally defend their rights, and they have in the past. It is historically and constitutionally wrong to think the legislative and executive branches are helpless against judiciary actions. Third, the Supreme Court could intervene to eliminate this attack on the executive branch by district judges. Chief Justice Roberts could end the growing confrontation by establishing a rule that any nationwide injunction issued by a district court against the executive branch would be suspended in implementation and immediately taken up by the Supreme Court. This would remedy the lengthy appeals process. Fourth, the Congress and the President can take decisive steps toward bringing the judiciary back into a constitutional framework. This hearing is a good first step. There could be a series of hearings on the constitutional and historic framework which ensures no single branch of government can acquire dictatorial powers, specifically the judiciary and this committee. These hearings would educate the members and the American people. They would create a national understanding of the need to defend the Constitution against overreaching branches of government. I would also recommend that the Congress pass Chairman Iss's No Rogue Rulings Act, which is a good signal to the courts that they have gone too far. Thank you, and I look forward to your questions.
Thank you. Ms. Romero.
My name is Cindy Romero. I'm a wife, a mother of 5, a grandmother of 3, a part-time worker and student, and a former resident of Aurora, Colorado. I'm one of the many victims across the nation of the violent transnational gang, Trinidad, and a former lifelong Democrat. My husband and I resided at the Edge of Lowry apartment for 4 years. And while the first few years were a pleasant experience, we soon began observing changes in our once quiet neighborhood. And in the spring and summer of 2024, we noticed shuttles dropping off large number of illegal immigrants onto the property. Throughout the year, we watched in horror as a few apartments full of migrant families quickly evolved into large groups of gun-toting, military-aged males, threatening the remaining leaseholders into abandoning their properties, then kicking in the doors to the many vacated units to make room for other gang members. Open-air drug use, drug dealers, and seemingly underage prostitutes filled the common areas of the buildings. Large parties in the parking lots lasted well into the morning. Stolen and abandoned vehicles blocked residents' cars, property damage was evident, and random shootouts soon began to be expected on our block every night. These criminals brought in unlicensed electricians to run electricity to abandoned apartments and locksmiths to change the locks on the outside of the buildings to deny access to the owners, emergency services, and even the leaseholders of the building. Despite several calls for help to the Aurora Police Department, they often provided conflicting excuses for not responding. For example, one officer told me that he wanted to respond, but was instructed not to. or they were often responding to other rampant crimes across the city, or had to respond to any crime in my neighborhood with no less than 3 or 4 officers and an armored vehicle. One officer suggested I go to the media because he felt sorry for me. He likely unintentionally saved my life. Although we were low income and barely paying our bills, we realized the need to invest in home protection, and we purchased 3 additional handguns and 6 cameras in the event that we had to defend ourselves. And during June and July, the gang members slowly began to torture us through intimidation, loud arguments, physical conflicts outside our door every night, vandalizing, taking over vacant apartments on our floor. And after several confrontations with the gang members, several calls, and submitting video evidence to the Aurora Police Department with no results, we gave up trying to stop them from squatting on the property. We spent the next few weeks looking for another rental, and we were unable to locate another low-income property rental that didn't have the same exact issues that we were facing every day. We reached out to local mainstream media, several NGOs in our community, begging for help, only to be turned away because we were just ordinary taxpayers. There were no government programs to grant citizens temporary protected status from imported gangs in our own country. On August 18th at 11:21 p.m., 10 minutes after my now viral video was recorded, a young man who I called my friend was mortally wounded outside my apartment during a firestorm of bullets, causing thousands of dollars in damages to cars and surrounding properties by 6 gunmen later identified as Agua. And thanks to the heroism of one local Aurora City Councilwoman named Danielle Durinsky and some of her friends, including John Fabricatori, they'd been sounding the alarm over TDA for months while being called a liar and ignored by their governor. I was finally able to escape these horrible conditions due to their help. In the media frenzy following the video release, many TDA members have now been identified and arrested all over the country. Danielle Durinsky has never received an apology or acknowledgement for exposing the threat. When I heard that Mr. Trump had taken an interest in Aurora and our struggles with Agua, I was relieved. I was hopeful that a change was, getting ready to happen, that it was on the way, that it was impending. And as president, he did not disappoint me. And I feel safer knowing that our country becomes more secure daily. I continue to think that the lives of my family and many others in my community were put at risk by the Biden administration's failed sanctuary policies at the southern border. Sanctuary status puts citizens at risk. And we must stop pushing ideology over common sense. Thank you.
Thank you. Would you show the video before we move on, please?
It's scenes coming out of a movie as the Venezuelan gang Tren de Aragua are seen breaking into apartment complexes in Aurora, Colorado. This is according to our sister station in Denver. There you can see the group well armed and forcing an apartment door open and making their way in. This has raised concerns amongst residents and Colorado state law enforcement officials.
Thank you. Professor Shaw.
Chairman Issa, Ranking Member Johnson, Chairman Roy, Ranking Member Scanlon, Chairman Jordan, Ranking Member Raskin, and distinguished members of the subcommittees. Thank you for the invitation to testify today. My name is Kate Shaw. I'm a professor of law at the University of Pennsylvania Carey Law School. I understand that the purpose of today's hearing is to discuss recent judicial rulings against the Trump administration and to evaluate some of the responses to those rulings being considered by this body, in particular, resolutions of impeachment against federal judges and a bill that would limit the power of district courts to issue nationwide injunctions. Let me say at the outset that in my view, the premise of this hearing, that courts have overreached or transcended the limits of their authority and that this overreach calls for some response, is badly mistaken. It is true, as has already been noted this morning, that the Trump administration has been on a losing streak in the federal courts. A recent analysis by Professor Steve Vladeck found that of the 151 cases brought against the Trump administration since January 20th, 46 have resulted in some sort of preliminary relief. That relief has been ordered by judges across the country and by judges appointed by presidents of both parties. This broad consensus makes clear that despite the claims of some critics, these rulings do not grow out of substantive disagreements with President Trump's policy choices. The lawsuits have been brought and have overwhelmingly succeeded because many of the challenged actions have been taken without regard for and often with outright contempt for both statutes and the Constitution. And by that I mean both the constitutionally required process for lawmaking and the rights the Constitution commands government to respect. First, as to process. Article 1's lawmaking provisions are pretty straightforward. Laws must be passed by both houses of Congress and signed by the president or repassed over a veto. Laws governing funding, that is appropriations, are laws like any other. As for Article 2, it has long been settled that when the president acts, it needs to be pursuant to some authority Congress has granted or within one of the narrow areas in which Article 2 gives the president the authority to act without congressional authorization. That is the heart of Justice Jackson's concurring opinion in Youngstown, still the most influential judicial account of presidential power. What all of that means is that if President Trump wished to reshape or even eliminate many federal agencies, or dramatically reduce government expenditures on foreign aid, or eliminate job protections for federal workers, or roll back federal privacy protections, working with his many allies in Congress, including those on this committee, was the constitutionally permissible way to do that. Instead, he has ignored the laws passed by Congress and the constitutional rules that give Congress primacy in lawmaking. Beyond those largely procedural failures, many of the administration's initiatives have flouted core constitutional principles: the freedom of speech and expression, due process, equal justice and equal protection under law. President Trump has used the power of government to exact retribution against individuals and entities who have engaged in constitutionally protected activities, and he has brought the full weight of the state down on vulnerable groups the Constitution protects. In short, this administration has been marked by a breathtaking degree of presidential unilateralism that is flatly inconsistent with the Constitution and with numerous statutes passed by Congress. That is true in general terms, and it is true as to specific actions. That is why President Trump has fared so badly in court. To be sure, some of these rulings will be, some already have been, reversed on appeal. Reasonable minds can disagree about some of these questions, but rather than focus on the appellate process or on correcting the legal defects, this administration and many of its supporters have suggested that the problem is district judges. And rather than use its constitutional authority to enact laws that would give the president the power to do some of the things he wishes to do, this body has devoted itself to two things: stripping the power of federal courts to issue injunctions and pursuing the impeachments of federal judges who have merely discharged their obligation to uphold the Constitution. To my mind, the district court judges who have ruled against the administration have not come close to engaging in high crimes and misdemeanors, the constitutional standard for impeachment. And although Congress has considerable power to regulate the federal courts, including potentially restricting courts' ability to issue nationwide relief, the current moment calls for caution in pursuing change that would curtail courts' ability to meaningfully review and remedy unlawful executive action. It has been suggested already this morning that rulings against the administration thwart the will of the people. But democracy does not begin and end with elections for president. It includes elections for membership in Congress, the branch closest to the people and the entity whose authority many of these decisions protect. Democracy also means more than just elections. It includes values like the ability to engage in speech and expression, to associate, to petition. Meaningful democracy also requires genuine political equality, procedural fairness, and mechanisms for the protection of minorities. And in our system, courts can be a key guarantor of those aspects of democracy. They are doing their part to preserve both law and democracy. Other branches of government should join them. Thank you again for the invitation, and I look forward to your questions.
Thank you. We'll now go in order, out of order, in order to give Mr. McClintock the first round of questioning.
Thank you, Mr. Chairman. The ranking member offers us an example of an upstanding, law-abiding Marylander in the case of Brego Garcia. As Mr. Ice has said, Mr. Garcia has been identified as a member of MS-13, the most violent criminal gang on the planet. And there's one report just published that he's implicated in human trafficking in this country. Not exactly Rotary Club material, I think. But shouldn't the circumstances of his case be examined in an individual action before a district court and not dumped into a far-reaching edict arising from another case that has very different circumstances? Mr. Larkin, what's your opinion of that? Your microphone.
How about now? My mistake, sorry. My understanding is these actions that have been challenged under the Administrative Procedure Act, not as actions seeking federal habeas corpus relief. Federal habeas corpus is the traditional remedy that someone uses when they're claiming the government has unjustly seized them. There's even a provision for next friends.
And that option exists in law, and I think that that's the appropriate option, is it not?
The Administrative Procedure Act is not.
Yes.
For example, you can't use Section 1983 to challenge the legitimacy of your conviction. You have to use the Habeas Corpus Act.
Right.
So
while again, these are individual cases with very different individual circumstances and ought to be
that's right. I mean, what you have, a particular John Doe, number 1, 2, 3, whatever. Each case has to be examined separately, but it should be in habeas corpus, not the Administrative Procedure Act.
Mr. Gingrich, I'm told that 92% of the judges who've issued blanket injunctions against the administration have been appointed by Democrats. That at least suggests a rather partisan tilt to all this, and it's not being done even-handedly. What's your view of that, and doesn't that undermine public confidence in our courts?
Well, I think if you look at the recent reports from various polling firms, clearly a majority of Americans believe that no single district judge should be allowed to issue a nationwide injunction. And I think that when you look, my judgment as a historian, this is clearly a judicial coup d'etat. You don't have this many different judges issuing this many different nationwide injunctions, all of them coming from the same political ideological background, and just assume it's all random efforts of justice. This is a clear effort to stop the scale of change that President Trump represents. And I agree, a lot of this stuff can be fought out, some of it should be fought out in the Congress, but it shouldn't be micromanaging the executive branch on national security issues by random single judges who have no standing, they have no particular knowledge, they haven't been in the room, they don't know what the consequences of what they're doing are, and they put both Americans and the nation at risk when they intervene to become basically alternative presidents. You now have potentially 677 alternative presidents, none of whom won an election.
Well, we all believe in due process. Every injured party should have access to the courts, and they do. The question is whether a single district court can go beyond the case before them and apply the same decision to others whose cases are not before the court in jurisdictions that go far beyond their own. Mr. Gingrich, you've pointed out that there are several ways to address this. One is congressional action. The other is the Supreme Court putting its own house in order. In fact, the Alito dissent recently suggests that there are at least 4 of the justices who very much want to do this. It seems to me that's the cleanest and most surgical route, assuring that the rule is done from within the court and not imposed by legislation. What are your views on what the Supreme Court should do and on what you already mentioned what we should do?
Look, I think the Chief Justice would achieve far more for judicial independence if he cleaned up his own judiciary rather than lecturing the rest of us. And I think there are ways he could intervene, as I mentioned in my testimony. They could establish a rule that any nationwide injunction issued by a district court will be held in abeyance and will be immediately appealed to the Supreme Court. You know, Lincoln makes this case. Very head-on fight, which is ironic because Chief Justice Taney, as Attorney General for Jackson, had ruled against the courts and had said as Attorney General, the courts cannot order the president. Now, he then becomes Chief Justice, extends slavery potentially to the whole country, and is lectured by Lincoln in his first inaugural as Taney sits there. And Lincoln is essentially saying, this was the law of the case, not the land, and we will not enforce it. And they don't. They never enforce Dred Scott. And so I think Chief Justice should think seriously about intervening to preempt any requirement for something such as Chairman Ice's bill, which I support strongly, but would be no reason to have it if the Chief Justice did his job.
Thank you.
I thank the gentleman. I now ask unanimous consent that the previously played video be placed in the record. Additionally, I ask unanimous consent that the Wall Street Journal article entitled "Why Judge Boasberg's Deportation Order is Invalid, Legally Invalid" be placed in the record, and that the Harvard Law Review article entitled "District Court Reforms, Nationwide Injunctions" be placed in the record. Without objection, so ordered. And we now go to the ranking member, Mr. Johnson, for 5 minutes.
Thank you, Mr. Chairman. I'm reminded of the quote that goes something like, when the law is not on your side, argue the facts. And when the facts are not on your side, argue the law. And when neither is on your side, then pound the table. Well, Trump doesn't have the facts or the law on his side. And so with this exercise today, he is vicariously pounding the table. Professor Shaw, President Trump has targeted and attacked some very wealthy and powerful entities to send a message to the less powerful. Trump has attacked Columbia University. He has attacked the white shoe, silk stocking law firms like Paul Weiss and Skadden Arps. These powerful, wealthy entities can afford to sue to protect their interest and our rule of law. But instead, they chose to lay down and get steamrolled by the bully. Professor Shaw, how does laying down and getting steamrolled compromise the rule of law and undermine our democracy?
Let me just say that, there have been targeted entities, right, including a number of law firms that have, in fact, not laid down, that are, in fact, taking a strong position of resistance to what they believe to be the unlawful components of some of the targeting orders. So law firms including Wilmer Hale, Jenner & Block, Perkins Coie, have made their responses and their views of the impermissibility of the targeting of law firms for no reason other than their decision to take on disfavored representations and to advance legal arguments that the president has personally objected to and sometimes been on the receiving end of. And so, I do think that calling out clearly unlawful executive action is critically important, particularly for entities with resources and stature. And I think that it encourages the targeting in unlawful ways for institutions to refuse to take a stand. I think that the orders targeting law firms are clearly unlawful. I think that some judges have already so found, and I think that the judges that rule on those orders will continue to find that. And the last thing I'll say is I think that law firms that have decided not to fight and that are complying haven't bought themselves any security necessarily. I'm not sure there's any guarantee that they won't be subject to further targeting simply because they have acquiesced in sometimes coercive terms in the first instance.
Yeah, when the bully knows that he can bully you, then he's going to continue bullying you until you stand up. And so I'm glad that these other law firms and other academic institutions have and are standing up. What would happen to access to justice for the least of these if these very wealthy and powerful entities that are being targeted today if each and every one of them laid down and just allowed themselves to be steamrolled?
I think there could be a chilling effect in the willingness of law firms to take on disfavored representations. You know, the targeting has not been limited to law firms either, right? There has been an effort to suggest that sanctions will be sought by the Department of Justice against nonprofits and other legal actors that have engaged in litigation against the administration. And so it does seem quite clearly designed to reduce the amount of courageous litigation against and challenges to executive action. And so, you know, I think that the potential costs for the rule of law are, you know, incalculable.
Yeah, because it's based on the adversarial system. And if you wipe out the adversaries, then you wipe out the adversarial system or the adversary system.
I think that's right, that attacks on, you know, look, lawyers are not always popular, right? So attacking lawyers is not something that everyone is always going to object to, but judges need lawyers to present arguments to them, and our system of justice and the rule of law requires lawyers to take on representations, including potentially unpopular representations. So I do not think these attacks on, you know, white shoe law firms should be understood as just about white shoe law firms. I do think they are attacks on the very idea of access to justice and to the rule of law.
And when you attack, in addition to the lawyers, you attack the judges and claim that they need to be impeached, not for committing high crimes and misdemeanors, but for simply ruling in a way that is against the bully. What impact does that have on our justice system and our democracy?
I worry that the intent there is the same, to basically have a chilling effect on the willingness of judges to rule against the administration. In the same way, I think part of the intent of these executive orders is to create a climate of fear and intimidation and to disincentivize taking on representations, including against the federal government. So I think the intended effect is likely the same.
Thank you.
Thank you.
I yield back.
And yields back. We now go to the gentleman from Kentucky, Mr. Massey.
Thank you, Mr. Chairman. This hearing reminds me of a breakfast I had with Antonin Scalia. About a dozen of us congressmen invited him to breakfast, and this was about a decade ago when Obama was the president and John Boehner was the speaker. And my colleagues appealed to Scalia and said, what can you do? You need to get involved here. The courts need to get involved. Obama's running roughshod over Congress. And Scalia refused to accept that premise. He said, no, this is not my job to referee fights between your two branches. My job is as a jurist to decide if somebody's been harmed and what the remedy is. And occasionally we interpret the law and the constitutionality of it. He said, and by the way, you're the most powerful branch of government. I don't know what you're complaining about. All the tools you need to restore the balance are in the Constitution. And one of my colleagues protested that impeachment was just too hard to pull off, given the threshold in the Senate and the political backlash. And Scalia shook his head. He said, I'm not talking about impeachment. You all have the power of the purse. You are funding everything you complain about that Obama is doing. Just quit funding it. And it was a pretty clear message. Now, that was about tension between Congress and the executive branch, and our hearing today is about tension between the judicial system and the executive branch. But I think it's still the case that what Scalia said is true. Let me give you an example of something I'm going to predict is going to happen in the courts soon that I'm not going to have much sympathy for on the president. So the president recently had a press conference and said he's going to wind down the Department of Education. Oh, great, that's my bill. I've got a one-sentence bill that eliminates the Department of Education. I should be very excited about this. The problem is, much of the activity that he says he will undertake, he just signed into law the funding of it a week before. We did a continuing resolution that fully funds every single penny of the Department of Education, then a week, and the president signed it. This is, as Professor Shaw pointed out, appropriations bills are laws too, and they require both chambers and then the president to sign it. And so it's an appropriation bill, it's a law, it's in law, and a week later, he announces that he doesn't like some of the law, and so he's going to do things differently. So that's my problem that I have. Now, I do think it's a good hearing, and this is a great question. I tend to think that probably there are cases where they shouldn't have nationwide injunctions, but this is a double-edged sword. Under the Biden administration, he did unconstitutional and unlawful things during COVID that were stopped with nationwide injunctions. So, for instance, he had a rent moratorium that was stopped until the Supreme Court eventually basically said it was illegal. He refused to grant religious exemptions to the vaccines in the military. There was a nationwide injunction. Actually, one of the attorneys in that is a constituent of mine, Chris Wiest, who stopped all of the vaccine mandates at that point in the Air Force. That was a nationwide injunction. And then his OSHA vaccine mandate was stopped with a nationwide injunction. So I'm torn on this. Maybe if we just don't have nationwide injunctions, people in certain districts can live under tyranny or the perception of it. And if you're in a different judicial district or circuit, you get some remedy from the tyranny. Maybe it works out better that way. Maybe we should have tried each of these cases in each of these courts and found out the answer. But Mr. Speaker, former Speaker Newt Gingrich, what do you have to say on since you were Speaker and led this appropriations process, do you think the president can unwind the Department of Education a week after he signed the bill that funded it?
Well, as you know, when I was Speaker, we balanced the budget, something you believe in, for 4 straight years, the only time in the last century. So I think I can talk with some authority about this. I suspect there will be a real fight at the Supreme Court level over whether or not the president has impoundment authority, which was taken away during the collapse of the Nixon presidency, but had existed before that. That'll be a legal fight. I think your point about injunctions is semi-right. That is, a court should be able to issue the injunction. My point about the Chief Justice is, if that particular single district judge says, this is a valid injunction, if they immediately went to the Supreme Court, and then the Supreme Court agreed that it was a valid injunction, then you could have a nationwide injunction. But I'm with Lincoln, who said even though the court had decided 7-2 that slavery could be extended nationally, he refused to accept the legitimacy of that decision because it wasn't unanimous. Now, so the precedent is pretty clear. I think your instinct is right. There are times you need a nationwide action. My only point is, if the district judge says that, the following morning it should be in the Supreme Court, and the Supreme Court should have to render judgment. If they agree, then you have a nationwide injunction. But if they say, no, you're in error, then there's no nationwide injunction.
Makes sense to me. I yield back.
I thank the gentleman. We now go to the ranking member of the full committee, Mr. Raskin, for 5 minutes.
Thank you, Chairman Issa. Respect for the separation of powers is intertwined with respect for due process of the citizens. The gentleman from California essentially invited us to accept the deportation of someone from America without any due process at all, which the administration has admitted was a mistake because now he's hypothesizing that person belongs to a different criminal gang and engaged in other different hypothetical crimes. And obviously, the reason why we have due process is because we can't try these cases in the Judiciary Committee of the House of Representatives. But just reading from a court document here, Plaintiff Abrego Garcia is not a member of, nor has any affiliation with Trenta Aragua, MS-13, or any other criminal or street gang. Although he's been accused of general gang affiliation, the U.S. government has never produced any evidence to support this unfounded accusation. He has no criminal history. He's never been charged or convicted of any criminal charges in the United States. So who knows? That's why we have due process. This shouldn't be just fodder for cable TV. We're talking about people's lives here. Professor Shaw, what does due process actually mean? And should Judge Boasberg be impeached for saying that the Alien Enemy Act of 1798 doesn't apply because we are not at war and we have not suffered an invasion by a foreign power?
The core components of due process are straightforward, right? And it involves some notice and an opportunity to be heard, right, to make some sort of case in your own defense prior to deprivation of life, liberty, or property. So that's in the Constitution. Due process applies to every person, not just to citizens. And due process doesn't look identical if we're talking about due process in the context of potential deportation or due process in the context of, a change to your Social Security benefits, right? Due process is deeply context dependent. And all Judge Boasberg has ruled as a preliminary matter in this case is that some sort of process has to be afforded before this potentially irreversible act occurs. Judge Boasberg has not ordered anyone released in the United States, has not objected to the detention of the covered individuals, has simply said provide reasons and an opportunity to respond. And
follow the law, right?
And follow the law. And it seems from public reporting as though there is real reason to believe that errors were made.
My colleagues are calling for the impeachment of Judge Boasberg. Has there ever been a federal district judge, a federal appeals court judge, or a U.S. Supreme Court justice impeached because someone disagrees with the content of their ruling?
We have no tradition of impeaching judges based on the contents of their rulings.
We impeach them for bribery or corruption or habitual drunkenness on the bench. Speaker Gingrich, by the way, do you agree with the Republicans and with Donald Trump and Elon Musk who are calling for the impeachment of these judges? That's a yes or no.
I actually agree with Jefferson that impeachment is a cumbersome and difficult process, virtually impossible to achieve, which is why Jefferson...
So you oppose the impeachment?
Which is why Jefferson abolished 14 courts, because you could abolish...
Okay, Professor Shaw, forgive me, you remember the 5-minute rule. I've got no more time. It's a yes or no question, and I didn't get an answer from you. The Chief Justice Roberts has said that the correct response to disagreement with a district court decision is to appeal. I just heard Speaker Gingrich call this a judicial coup d'etat, and he said the Chief Justice should stop lecturing the rest of us. Who's right? Is it Newt Gingrich or is it Chief Justice Roberts here?
In this instance, Chief Justice Roberts. We have no tradition of impeaching judges. Appeal is the remedy for disagreeing with the district judge. Or if it's a statutory ruling that's wrong, Congress can respond, right? If it's if there's a bias or misconduct issue, there are disciplinary processes and complaints that can be brought against judges. You can seek to recuse or a remand to a different judge. There are many remedies our system affords if there is some sort of problem with the judge presiding over a case. But impeachment has never been in that toolkit.
Do you believe that there has been a conspiracy for a coup d'etat among 34 U.S. federal district court judges appointed by Presidents Reagan, Bush, Clinton, Bush, Obama, and Trump?
No, as you said, I think these judges are simply doing their jobs.
The only comparable case I can think of here is the impeach Earl Warren movement after Brown versus Board, where there were racist segregationists who wanted to impeach Earl Warren because they did disagree with the content of his opinion. What happened with that? And do you think that he should have been impeached?
As far as I know, there were non-impeachment resolutions introduced at that time. There was rhetoric, there was critique. And to be clear, criticizing judges is absolutely healthy in a democracy. I am not suggesting otherwise. But this is already a pretty serious escalation to have seen these resolutions introduced. I really don't think they should go any further.
Thank you. I yield back, Mr. Chairman.
Thank you. We now go to the gentleman from Wisconsin, Mr. Fitzgerald, and I would ask if I could have 15 seconds of his time.
I yield back to the chairman.
Okay. Mr. Speaker Gingrich, I just have one short question, and it is a yes or no, unlike the other one. In your 2 decades as a member of Congress, did you see members of Congress put bills in of any sort because they were popular and felt strongly within their district, whether or not they were moving anywhere?
Of course.
And that would include things like impeachment, whether they were likely to succeed or not.
They're political symbols, not legislative symbols.
Very good. I thank you. I thank the gentleman from Wisconsin.
Reclaiming my time. Mr. Larkin, nationwide injunctions, they're relatively new phenomenon, right? Isn't that correct?
Yes.
Yeah, it's fair to say nationwide injunctions became more commonplace in the 60s and 70s, and that is because Congress began authorizing general rulemaking by federal agencies, such as passage of Clean Air Act or the Clean Water Act.
Well, there are several factors that led to the late development of it. One is a change in philosophy of what it meant to say that something was unconstitutional. For example, Professor Samuel Bray explained this at length in his article. Traditionally, when a court said something was unconstitutional, it meant the government could not enforce it against you. Over time, courts gradually began to say, no, that means you can't force it against anybody. The problem is that overlooks the role that a district court judge has both horizontally and vertically within the federal system. No one district court judge can bind the appellate court or the Supreme Court. No one district court judge in Maine can bind a district court judge or any judge in Alaska. And so, unfortunately, this practice developed, and we didn't have anybody stepping back and saying, no, wait a minute, are there constitutional, statutory, et cetera, limitations on it? And it has actually hurt both parties, because each party has suffered through this process.
Thank you. Speaker Gingrich, as you mentioned in your testimony, between 2001 and 2023, there were 96 nationwide injunctions issued, of which 64 were granted against President Trump. Well, why do you think the courts have issued nationwide injunctions against President Trump with such frequency? It's kind of a question we're all pondering right now.
You know, one of my favorite books on the law is The Bramble Bush, which is the 1929 introductory lectures at Columbia Law School, and which draws a distinction between the law as it is practiced and the law as it is written. So let's just, at a common sense level, be honest. Donald Trump represents a profound, fundamental shaking up of a very deeply resistant establishment, which can be traced back to Franklin Roosevelt in 1933. You take on a system that's almost 100 years old, the system fights back. The last great bastion of power held by the left is district court judges and their allies on the Supreme Court. And they're behaving, as a historian, this is a perfectly natural thing. They're doing everything they can to stop the president, who was elected by millions of Americans. They were elected by no one, but under our system, they have a certain amount of power. Not nearly as much as the modern legal system believes, because the 1958 decision by the Supreme Court, which said we are supreme, is baloney. The Supreme Court is supreme in Article 3. It is not supreme over the whole Constitution. And I think we're now going to face a genuinely important, historic conversation as a country about whether or not unelected judges on a randomized basis, who happen to be 92% Democrat, have the power to stop the elected commander-in-chief on item after item after item. My guess is the American people will say to the legislative branch, you got to be kidding me. And if Justice Roberts wants to cut this off, he should act now, because this is going to get worse, not better.
Thank you. Mr. Larkin, I'll just finish up with a quick question about forum shopping. It's something that's clearly been happening, and we're used to it at the state level within the judiciary as well as at the federal level. I was wondering if you had a comment about that.
Sure. I mean, the problem is attempted to be avoided by having random assignment. But unfortunately, there are some times when there's only a limited number of judges in a particular district. And as the result, if there's only one, that's who you're going to get. If there are two, you have a 50% chance. And people wind up doing this, not surprisingly, because they think Judge A is going to give them a better likelihood of success. Now, you know, that's bad enough when what you're talking about is a damages action, because that damages action is going to result in a check, perhaps, that goes just to one party. It's different when you're talking about having one judge in any one town enjoying the entirety of the federal government across the nation. That's a much more severe problem, and that's why this is a reasonable effort to cabin that. And, you know, picking favorable judges is a reason why.
Thank you. I yield back.
Thank the gentleman. We now recognize the gentlelady from California, Ms. Lofgren, for 5 minutes.
Thank you, Mr. Chairman. It seems ironic that today's hearing is titled Judicial Overreach and Constitutional Limits on the Federal Courts, because if we really care about constitutional limits, we should start by confronting the recent attacks on judicial independence, attacks that themselves defy the Constitution. In the past few months, we've seen Elon Musk, President Trump, and even members of Congress call for the impeachment of judges, not for misconduct, but because they don't like their rulings, and that's not how a constitutional democracy works. You know, it's true that members of the judiciary were not elected by the Electoral College. That is beside the point. As my colleague, Mr. Massey, pointed out, when Congress enacts a law, signed into law by the president can overturn that law with a statement, which is essentially what an executive order is. And that judges are making that finding is the role that they have been assigned. Now, Professor Shaw, the recent federal court decisions, which, by the way, have been made by judges appointed by both political parties, have led to calls for the president's supporters to impeach these judges. Now, only 15 federal judges have been impeached by the House since 1804, and only 8 had been removed by the Senate. I was involved in one of them for a very severe misconduct case. What's the standard in the Constitution for impeachment for a federal judge?
Well, it's been understood that the constitutional language of treason, bribery, and other high crimes and misdemeanors applies with full force to federal judges, although it's actually not explicit in the Constitution, and there are some scholars who have raised some questions about it. But our practice is consistent that that is the same standard that applies to other officers. It applies to judges. And in terms of how our practice has implemented that standard, it has been exactly as you said. In the 15 judicial impeachments that have resulted in 8 convictions and removals, they have been for serious misconduct, things like habitual drunkenness, sexual assault, or corruption, bribery, those types of offenses. The one impeachment of a Supreme Court justice, Justice Chase, was somewhat different because it involved explicit partisanship from the bench. But there you had repeated jury charges and actually kind of electioneering from the bench that also clearly distinguish the conduct at issue there from any of the rulings at issue here. So just to be succinct, none of these historical examples have anything to do with the substance of the rulings rendered by the judges who were subject to impeachment.
Well, and even for those who cite the section of the Constitution that judges serve during times of good behavior, that wouldn't include disagreement with the outcome of a case.
No, I would say the combination of the good behavior language and the impeachment language has suggested that the way to implement the requirement of good behavior is through impeachment. There is no other mechanism that we have ever used to remove judges other than the impeachment mechanism. And certainly there's nothing to suggest that disagreement with a ruling, whether we're talking about as a matter of good behavior or the specific impeachment language, would ever be the basis for seeking to remove a federal judge.
Senator Chuck Grassley, chairman of the Senate Judiciary Committee and hardly a bleeding heart liberal, recently said, and this is a quote, "You can't impeach a judge because you disagree with their opinion." I take it you agree with Senator Grassley's statement there?
I do.
Now, would doing so be damaging to our constitutional system of separation of powers? And if so, why would that be?
I do want to be clear that I think that there is a healthy inter-branch debate and dialogue that can include criticisms, including sharp criticisms of the rulings handed down by district judges, appellate judges, Supreme Court justices, and that can include hearings that consider and maybe adopt legislative change, right? Obviously, Congress has considerable authority to regulate the jurisdiction of the federal court, so I don't think any of that is unhealthy or destructive, but I do think that moving into an era in which substantive disagreement with the rulings of federal judges gave rise to impeachment proceedings would involve an escalation of this kind of interbranch warfare and a politicization of the judiciary that would be extremely damaging to judicial independence and to the role of courts in our democracy.
Thank you very much. Ms. Romero, I found your testimony riveting, and I'm sorry that you and your neighbors went through such a nightmare. There is not a single member of this committee on either side of the aisle that doesn't want violent criminals who in this situation to be deported. The issue is standing up for the rule of law, making sure their due process when that is done. And I want you to know that I listened very carefully to your testimony. I'm sorry what you went through.
Thank you very much.
Thank you. We now go to the chairman of the full committee, Mr. Jordan.
Thank you, Mr. Chairman. Professor Shaw, so was Judge Boasberg correct when he said turn the plane around?
So, I think that protecting the jurisdiction of his
Wait,
court.
that wasn't the question. Was he correct when he said, turn the plane around, bring the guys back who harassed Miss Romero, drove her out of her home, harassed her neighbors, shot her car? Was he correct when he said, turn the plane around, bring those individuals back to the United States?
Based on the record before him, I think that was an absolutely defensible decision to have made in the time-pressured condition.
Miss Romero, what do you think? You agree with the professor and with the judge? Three of those individuals on the plane, Thomas Murillo Pena was wanted for kidnapping in Chile, was in the Denver area where they got him. Javier Vargas Lugo, attempted kidnapping, was in the Denver area. Nixon Azusa Perez was in the Aurora area. He may have been one of the guys who harassed you. Do you think that plane should have came back and brought those individuals back to the United States?
I feel safer every time a plane is loaded up and leaving this country.
Yeah, the previous member from California talked about your riveting testimony. One of the lines you had in your testimony that got everyone's attention was, quote, there are no government programs to grant citizens temporary protected status from imported gangs in our country. Amen to that. There is none. And that's why this is so important that we move these people out. Mr. Speaker, should the judge who's been assigned the Hegseth case, Judge Boasberg, should he recuse himself from that case? And understand the standard, I know you do, Speaker. The standard is a reasonable person. Would a reasonable person believe that this judge can't be impartial with this case? And I would just remind you of a couple things. This is the judge who was on the FISA court when they granted warrants to spy on President Trump's campaign. This is the judge who handled the Kevin Kleinsmith case, an FBI lawyer who lied to the FISA court to help get those warrants and was given a slap on the wrist by Judge Boasberg. Not my words, the Wall Street Journal said it, because it was. He was a member of the bar, lied to a court, and got some probationary sentence. So now this judge said, turn the plane around, and now he's been assigned the Hegseth case. And I'm just asking, do you think Judge Boasberg should recuse himself from that case?
I think this is a classic case where the Chief Justice should intervene. I mean, when you have a blatant, continuing record of prejudice, that judge should not be put in charge of a case. And as I said earlier, I'm not for going through the whole process of impeachment because I think it's at a practical level not possible. I am, however, for using the potential capacity of the Congress to simply defund, which Jefferson did and which clearly is possible. But I think what you just described is illustrative of why I use the term coup d'etat. You have a small group of people who believe that they have the right to arrogate rejecting the American people and doing whatever they want and cooperating with people who clearly were behaving illegally. I mean, that's one of the great tragedies of the last 6 or 8 years is it's the government which has been illegal. It's the FBI which was illegal. And how can you possibly have the rule of law when the people in charge of the law are illegal? I think in that case, you raise a very powerful point.
Mr. Larkin, should Judge Boasberg recuse himself in the Hegseth case?
Oh, I don't want to offer an opinion about a specific case that I'm, know only.
Do you think Judge Boasberg, based on what the Speaker just said, what I highlight, think Judge Boasberg has a bias against President Trump and what he's trying to accomplish?
That's just phrasing the same question another way. I don't want to comment on a pending
That's what we do in Congress. That's what
yeah,
we
I know.
do a lot of time.
Yeah, when I was an agent, we did the same thing to see if we could get the suspect to say something
How
different.
about this, Speaker Gingrich? I think you're exactly right. We have 3 avenues to address this. We can do legislative, which we're going to do tomorrow. We're going to pass Chairman Iss's bill, which says that some district judge injunction doesn't apply nationwide. We may want to come back with another bill that says automatic appeal to the Supreme Court, what you've suggested, and we're looking at that very thing. Second, we have oversight, which is what we're doing now. We're highlighting how ridiculous some of these decisions have been. Yeah. And third, what you pointed out is we got the appropriations process. The ultimate power we have, Mr. Massey's right, the power of the purse, we should use it. We should use all 3 of those avenues to make sure the will of the people, we the people, gets accomplished.
Well, my personal view is that if you were to pass the ISA bill tomorrow, you just sent a very clear and compelling signal to the Chief Justice
Sure did.
that he had better get out of lecturing the Congress and get into managing the judiciary, or he's going to be facing a real crisis of the system and a real erosion of judicial authority.
Well said. I yield back.
Gentleman yields back. We now go to the gentleman from Tennessee, Mr. Cohen.
Thank you, Mr. Chairman. The judicial branch in our country plays a critical role in checks and balances, which is the Constitution mandates. Our president doesn't understand that or respect it. And in my opinion, he accordingly is the one doing the overreach, not the judiciary. He overreaches with birthright citizenship, which is in the Constitution, and he can't, with an executive order, a press release with a nice stationery and a little sign on it, overrule the Constitution. Nor can he declare a third term for himself, which he'll probably do eventually, that he can run for office again. He can't do that. This man is abusing the office of the president by signing executive orders in so many areas against a Congress for passing appropriations bill, which he doesn't respect, and by destroying agencies created by Congress, which he can't do because they're independent, like the Peace Institute. It's an independent, but he's gone in and taken it over. He's also gone after lawyers and law firms. And it's no mystery why he did it. Jenner and Block and Wilmer Hale, they are two firms that have had attorneys with them, Andrew Wiseman, who worked at Jenner and Block, and Robert Mueller, who worked at Wilmer Hale, who had cases against the president. To get into court, you've got to have an attorney. And if attorneys are fearful of having their opportunities to interact with the federal government, to enter federal buildings, to have clearances, they will be reluctant to take cases. That destroys the opportunity for the Justice Department, for the judiciary, for the third branch to work as a check and balance. You destroy it when you don't have somebody to give you entree into the courts. Professor Shaw, your testimony was brilliant. Just to ask you about a federal judge. A federal judge cannot institute a case, can they?
No, sir, they cannot.
So what they do is they take what lawyers put before them and then they determine what it is.
A case or controversy is brought to a federal court, and a federal court can resolve it. They're not a self-starting body.
But if lawyers are afraid to bring an action against the administration or the president, then the courts won't ever get a chance to do anything.
Absolutely, and I think it is important to understand some of the attacks on lawyers and law firms as indirectly attacks on the judiciary, as well as attacks on the ability of what causes the president may deem unpopular to secure representation or for litigation against the federal government to proceed. So I think that all of those values are implicated in the attacks on lawyers and law firms.
Do you remember some of the things President Trump said in his executive orders against some of these law firms about lawyers? Can you tell us, like they're criminal and they're trying to destroy our country and they're trying to, what were some of the other things he said?
So the law firm, the executive orders sort of singling out and targeting law firms begin with sort of a recitation of specific representations of disfavored individuals or representations that law firms have taken on. There are suggestions that the law firms are deceitful or dishonest, that they are committing fraud. But they're quite explicit, the orders, that it is the specific representations made by and viewpoints held by the attorneys that have given rise to the executive order. So I think that's why the lawsuits have framed these orders as containing attacks on the right to counsel, on the separation of powers, on independent judges, and on the First Amendment. There are, at least 4 or 5, I would say, independent constitutional flaws with each of these executive orders.
And they sounded like somebody like, first the lawyers. First we get the lawyers. It was the most anti-lawyer thing I've ever heard. I'm a member of the bar. I respect the bar, and I understand its importance to the American jurisprudence system and the government system at large. I'd like to yield 1 minute to Mr. Moskowitz. Thank you.
Thank you, Mr. Chairman. Thank you for yielding. It's so nice to see my Republican colleagues fight to protect executive power, but they aren't interested in fighting to protect this body and legislative power. Representative Gill from Texas filed impeachment proceedings against Judge Boasberg. It has 22 co-signers. He's not here at the moment. He's probably filing impeachment proceedings against Louis Brandeis. But Speaker Gingrich says that this is a cumbersome process, and Speaker Gingrich is absolutely an impeachment expert. Well, allow me to doge this cumbersome process for you, Speaker Gingrich. Why don't we just ask Chairman Issa or Chairman Jordan, when is the hearing on impeachment of Judge Boasberg? When's the hearing? Give me a date. Give the American people a date. Oh, wait, Chairman Issa says that this is actually a political symbol and not actual legislation. So it's a fake impeachment. When are you going to tweet that out? That ought to be popular. I mean, we had a fake impeachment for the last 2 years. I mean, I hope Representative Gill isn't a Comer. I mean, we got a Doge James Comer spending millions of dollars in 2 years on fake impeachments, but I guess that's what we do. We file fake impeachments now. That's what we admit.
I take back my time.
And I thank the
And
gentleman for
it's
taking back his time.
It's appropriate that on April Fool's Day that he discusses that.
Thank you. And since the question was posed toward me, I'll take the liberty of saying that we take all bills that are referred to our committee seriously, including that. And I would only say that be careful what you wish for. There will, in fact, undoubtedly be investigations of a number of judges, but we don't predetermine them in this committee. We don't denounce them when they're put in by a member. We also don't accept them as anything other than something for our staff to look at. But I appreciate the gentleman's question. With that, we go to the gentlelady from Wyoming, the senior member of the committee of the House from Wyoming, Ms. Hagerman.
The only. In March, the Miami Herald reported on a team of former U.S. officials and Venezuelans assisting the Trump administration with tracking Tendagua, or TDA. They have focused on ties between TDA and the Maduro regime, identifying 1,800 gang members sent to our country. Reportedly, 300 received paramilitary training in Venezuela, and the regime has operational control over them. Information obtained by the team from police agencies in South America has resulted in the arrest of at least 800 TDA members or smaller affiliated entities. According to the article, TDA has been setting up a drug distribution system in our country, and the individuals, quote, are not criminals sent to cause havoc. They are soldiers sent in an asymmetrical warfare operation against the United States, end quote. On March 15th, President Trump issued an EO invoking the Alien Enemies Act regarding the TDA invasion. The EO finds that TDA is perpetuating, attempting, and threatening an invasion or predatory incursion against the territory of the United States. TDA is undertaking hostile actions and conducting irregular warfare against the territory of the United States, both directly and at the direction, clandestine or otherwise, of the Maduro regime in Venezuela. Judge Boasberg of the D.C. District Court recently ordered the Trump administration to turn around removal flights bound for El Salvador carrying members of this Venezuelan terrorist group, TDA. Judge Boasberg's temporary restraining order at first was limited to the named plaintiffs, but he later provisionally certified a class for, quote, all non-citizens in U.S. custody who are subject to President Trump's order against TDA and its implementation. Mr. Larkin, what are the problems associated with the breadth of this order rather than it having being just applied solely to the parties in front of it?
There seem to be at least two issues. One is whether I'm told, I haven't seen the complaint, but I'm told that the complaint that was filed seeking relief was brought under the Administrative Procedure Act. That's not an appropriate vehicle for this. It should be the federal habeas corpus laws. But secondly, if you're going to grant class-wide relief, you have to first properly certify a class. The Supreme Court has so ruled and has told the district courts that they have to do first the job of certifying the class and only then awarding class relief. In footnote 1 in Baxter versus, I think it's pronounced Palmigiano, but don't hold me to that, the Supreme Court said the district court had gotten it wrong in that case for following the reverse order. So if that's what happens then is you're seeing some of the problems that can arise when a judge wants to stop an entirety of the government rather than award relief to one person, because there are steps that you have to go through in order to certify a class. And to my knowledge, although, like I said, I haven't followed that case, I don't know if those steps were followed. This is the first I've heard of it from you, so.
Well, and there's another problem associated with that as well. In the case involving TDA, the judges and other injunctions that have been issued, nationwide injunctions issued by these courts, they have not been requiring the party seeking the injunction to put up a bond, even though Rule 65 of the Federal Rules of Civil Procedure mandates that a party seeking a preliminary injunction or TRO must provide security, a bond to cover potential costs and damages to the party who is wrongfully restrained or enjoined. In fact, such a bond is a condition precedent for an injunction to be valid. So in light of that, does this violation or failure to require the posting of a bond undermine, if not actually nullify, the legality of Judge Boasberg's order?
I have to say, and it's going to sound like begging off, but I'm not trying to, that I haven't researched that effect in this sort of context, in part because I'm not sure how you set a bond in a case like this, where what you're talking about is essentially relief that should be granted under the habeas corpus laws. And so to the extent there are separate procedures that you have to follow in a habeas corpus action, I don't know to what extent that part of Rule 65 would apply.
So what I'd like to do is I would encourage you to read the opinion article in the the Wall Street Journal from yesterday entitled "Why Judge Boasberg's Deportation Order is Legally Invalid." And this individual, Daniel Huff, goes through the analysis of what is required under Rule 65 for an injunction to be enforceable. Yeah. And one of the problems associated with the decision is the fact that no bonds have been required in these injunctions.
And not every provision in the Federal Rules of Civil Procedure automatically translates over to habeas corpus, and I just don't know if that provision does. If it does, then it has to be addressed. If it doesn't, then you have a different set of rules that you follow.
Would the gentlelady yield for 1 second?
Sure.
Would your
Mr. Chairman,
thank you. Would your question be for all of these cases, not just the one that you were speaking of?
That is correct, for all of the injunctions that have been issued in these decisions around the country. And I also would ask unanimous consent.
Time is expired.
I would ask unanimous consent to submit 2 articles for the record. 3 articles. One is the Wall Street Journal article. Another one is the article I was referencing earlier as the U.S. tracks suspected Venezuelan gang members, a look at a group that's helping, and the executive order issued by President.
From Washington, Ms. Jayapal, for 5 minutes.
Jayapal, thank you, Mr. Chairman. Perhaps my colleagues on the other side of the aisle should consider that the very reason that Donald Trump has faced more nationwide injunctions than Joe Biden is precisely because Trump is grabbing unprecedented power from Congress and from the judiciary, power that is not accorded to any president because we do not have kings in this country. If you try to eliminate birthright citizenship, jail people for free speech, slash funding and fire people, and eliminate departments that are actually established by Congress, if you try to use Cold War era regulations to do mass deportations, then yeah, you're gonna get nationwide injunctions. So maybe if you don't like the injunctions, stop doing the illegal stuff. The argument that the judiciary has run amok is a very convenient political argument that's being weaponized to eliminate the fundamental checks and balances that our founders put in place to protect the independence of the judiciary from the political branches of government. If there are threats to the independence of the judiciary, they come when unelected billionaires try to buy court seats. They come when there is no ethics code that stops justices from being captured by special interests. The lower courts have played a critical role in this independence from political systems, delivering results that people from both parties have liked and disliked. During the Obama and Biden administration, lower courts did rule against the government in cases dealing with student debt relief and DACA. Courts have also ruled in favor of guns, religious liberty, and abortion restrictions. Democrats may not have liked those rulings, but we did not simply try to eliminate those courts or impeach those judges. And did you ever hear Republicans complaining about the judiciary when those favorable rulings were coming about? Of course not. One of the most important roles of an independent judiciary is upholding civil rights and liberties. The judiciary is often the last line of defense for protecting the vulnerable from the powerful and the minority from the majority. This is particularly true when it comes to immigration. Last night, we learned that the Trump administration mistakenly deported a father with protected legal status. This is the latest amongst numerous questionable deportations, including men being deported for having tattoos, for autism awareness, and the names of close family members. Trump's basis for these deportations is the Alien Enemies Act of 1798. This statute authorizes the president to detain and deport non-citizens when there is, quote, a declared war or an invasion or predatory incursion, end quote, by a, quote, foreign nation or government. Professor Shaw, could you briefly explain why the courts have determined why there is no appropriate basis for Trump to invoke the Alien Enemies Act?
Well, I should say it's all in a very preliminary posture, but Judge Boasberg issued his initial temporary restraining order essentially on the grounds that individuals who were subject to this deportation on the basis of this invocation of a 1798 statute that has been used 3 times in our history needed some opportunity to contest or present evidence before being sent to prisons in El Salvador. So this was, just to be really clear, Judge Boasberg did not order anyone's release inside the United States. Everyone is able to stay in U.S. custody. It was simply a determination that the basic demands of due process were not suspended by the invocation of the Alien Enemies Act.
And why are those due process rights so important in the immigration context in particular?
Well, so I think that the example that you gave, Congresswoman, of this reporting we saw last night of an individual who appears to have been incorrectly seized and sent to a prison, maybe there was some other basis, but not the specific Alien Enemies Act invocation basis for deporting him, makes clear that the stakes kind of couldn't be higher than in the immigration context, especially if we're talking about not just detention, but deportation and expulsion. Due process protects us from being summarily deprived of life, liberty, or property, and those interests in some ways are at their highest when we're talking about the government taking custody and potentially expelling an individual.
And this law was used, wasn't it? It was invoked by President Franklin D. Roosevelt to detain 120,000 Americans of Japanese ancestry during World War II?
That's right. It was part of the basis of the detention and internment of Japanese Americans.
And so these actions don't just affect foreigners. What's at stake are constitutional rights for all Americans. Can you explain to any American who might be watching this hearing why they should be concerned about their rights, given what the Trump administration is doing?
Right. I think that the Constitution is the only thing standing between any of us and being summarily placed on a plane. And judges are the ones who are often in the position of enforcing those constitutional rights. So this is not about protecting an other, right? This is about protecting all of us. And if the administration is not duty-bound to respect the basic requirements of the Constitution with respect to these individuals, it's not clear why it's duty-bound to respect those rights as to any of us.
I think that is a very important point, and I think we should be focusing our attention on how to best preserve our independent judiciary, not delegitimize it. Mr. Chairman, I'd like to submit an article, seek unanimous consent to submit an article for the record. This is from The Atlantic. An administrative error sends a Maryland father to a Salvadorian prison.
Without objection, so ordered.
Thank you. I yield back.
The gentlelady yields back. We now go to the gentleman from Virginia, Mr. Klein, for 5 minutes.
Thank you, Mr. Chairman. I want to briefly yield at the start to the chairman of the full committee for a few seconds.
Thank the gentleman for yielding. Professor Shaw, should Congress add 4 associate justices to the United States Supreme Court?
I think that Congress certainly has the power. I think that
you support packing the court?
Look, anything Congress does with respect to the court should be responsive to current conditions. So there have been moments when I thought that Congress should take seriously changing the size of the Supreme Court. So I certainly has the power to do it.
That's what I figured. That's what I figured you'd say. I yield back.
And find it interesting that to be responsive to current events that you would support adding 4 justices to the Supreme Court. Court packing, essentially, when many on the other side saw rulings that they didn't like over the past several years. Their response was to pack the court. Mr. Speaker, do you consider it appropriate to add 4 members to the Supreme Court when decisions come down that people don't like?
Let me say first, if I might, that hearing a Democrat talk about fake impeachments after the 2 fake impeachments of President Trump, which were repudiated by the Senate, I thought it was a lovely moment of historical awareness. Look, the Supreme Court's been at 9 since 1869. It's before that, it differed at times, but there's never been a serious effort. Roosevelt tried, and as powerful and popular as he was, the country has an instinctive sense of stability at that level. So I would say, barring something extraordinary, the Supreme Court, again, supreme in terms of the Article 3, not supreme in terms of the country. I think the Supreme Court is best dealt with carefully and cautiously, and it evolves over time. It's not always what conservatives like, it's not always what liberals like, but over time it has been a relatively stable part of our system.
Now that we have a Republican majority in the House, Republican majority in the Senate, and a Republican president, I wonder how those same Democrats feel about adding 4 new justices to the Supreme Court right now. Probably wouldn't be so excited about it. But Ms. Romero, let me ask you, since you were so directly affected by Tren de Aragua, are these gang members the kind of folks Americans want in our neighborhoods? Were they good neighbors when you lived near them?
No, they were not good neighbors.
I read your testimony. It's shocking what went on in your neighborhood. How long did you and your community suffer from this invasion?
My husband and I lived in the apartments for 4 years. For the last year and a half, it was pretty bad.
Now, if you went around an apartment complex with a rifle trying to kick in people's doors, you'd expect police would act swiftly to take you into custody, right?
Yes, anytime someone calls 911, I expect the police to come swiftly.
Yeah, that's the reason we have law enforcement, to respond to situations like that.
That wasn't my experience with the local police there.
Your cries for help went unanswered.
Yes, very.
Unfortunately, federal judges seem to have taken up those same talking points and taken issue with President Trump's administration, calling what's happening in communities like yours an invasion. They instead just call it a migration. Did it feel like a migration to you?
It felt like there were large groups of people moving onto the property to destroy it and cause me harm. It caused many of my neighbors harm.
Felt more like a textbook definition of an invasion.
Yeah, nobody made sure my rights were protected.
Do you think, what message does it send when a district judge in D.C. says the president can't take action to remove these violent criminals and invaders from your community?
I think the president was asked very specifically to take care of this problem, and promises made and promises kept. I feel like he is keeping his promise to me.
Do you think that these injunctions will make the problem worse in your community as it emboldens criminals and handcuffs law enforcement?
I think all sanctuary city policies are a mistake, and they're harmful to regular citizens. And there's no one in here fighting for my rights.
Well said. Thank you. I yield back.
Gentlemen yield.
I yield to the chairman.
Well done, Ben.
Mr. Larkin, there's been a question that I've been begging to ask. National injunctions. If a judge in Hawaii were to rule on something, what prevents shopping for a declaratory judgment on the opposite end of the country, maybe in Texas by the administration, and that judge ruling that there is no such injunction, ruling the opposite and creating a constitutional challenge as we currently have it?
Well, you put your finger on one of the great challenges, because due process has to assume that there's a balance and an honesty and an integrity in the very system. And when you start getting into an ability to shop, or this, by the way, this is true for a whole different zone in terms of civil litigation and trial lawyers and lots of things you could talk about where the system is crumbling because it is so clearly no longer balanced by due process and a pursuit of justice. And I think that it is a danger. And frankly, again, I think we're either going to eliminate nationwide injunctions, or the Supreme Court's kind of going to find a way to make them immediately a national question, not a single district court system. If we don't do something like that, I think the system is in real trouble.
Thank you. Gentleman from Colorado.
I thank the chairman. I want to thank all the witnesses. I have the privilege of representing Colorado in the Congress, and so I want to say to Mr. Romero, welcome to Washington, and thank you for being here. Mr. Gingrich, I wasn't planning on talking about impeachment, but I just have to spend a minute on it, given the statement you made just a minute ago. I think you said, if I'm not mistaken, you said the two impeachments against President Trump were repudiated in the Senate. Is that the right word you used? Yeah, okay. And would you describe the impeachment that you initiated against President Clinton 35 some odd years ago and the Senate's reaction to that impeachment in the same way?
Well, it failed, which is part of why Jefferson thought impeachment was not a realistic possibility.
Well, I would just simply suggest to you that, because I served as an impeachment manager in the second impeachment trial against President Trump following the attack on our nation's capital. And in that impeachment, as you well know, of all the presidential impeachments, which I suspect you've studied, 7 Republican senators did something that no senators had done in the history of our republic, which is voted to convict a president of their own political party. So I think that is a far cry from repudiation. I understand that it didn't meet the constitutional threshold for success. I,
Actually,
of course,
President
recognize
Johnson
that.
had the same experience in, I believe, 1868.
I will just, again, simply say to you that unlike the impeachment, no, one that's inaccurate, Republican senators, with respect to the impeachment trial of 1868 against President Johnson, that is not accurate. It's the first time in American history in which senators of an opposing political party voted to convict a president, but of their same party, but I digress. Want to talk to you about a phrase you used. I think this is accurate. You called it a judicial coup d'etat. Is that, am I right?
That's correct.
Okay. And you would describe, 14 federal judges appointed by a president of an opposing political party issuing nationwide injunctions against the president's executive orders as a judicial coup d'etat.
I would describe the wave of decisions in the last 7 weeks deliberately designed to slow down, unwind, and block the president as clearly an effort by a group of judges.
I hear you. What I'm asking you, again, I don't think I'm mischaracterizing your testimony. 14 federal judges, all of an opposing political party, that is to say, 14 federal judges appointed by a president of an opposing political party, issuing nationwide injunctions against the president's policies, in your view, would be a judicial coup d'etat.
It depends on how long the time was.
Sounds like it depends on the
between each
president,
injunction.
Mr. Gingrich, because the president I'm describing is President Biden.
I know.
During his tenure, 14 federal judges issued injunctions against policies that he pursued via executive order. How many of them were appointed by Republican presidents? Do you know?
No.
100%, all of them.
Well, you're making my case.
I'm making your case.
they
What's
shouldn't be able-
fascinating, Mr. Gingrich, is I didn't hear much from you about judicial coup d'etats when President Biden's policies were being rejected by federal judges across the country. It is very convenient now, lo and behold, that you take great issue and you describe it as a judicial coup d'etat when I didn't hear these words 2 years ago.
Had the Judiciary Committee invited me in during the Biden administration,
I see.
I would have been glad to say.
Well, I regret that Chairman Jordan.
I don't approve of.
I regret that Chairman Jordan didn't issue an invitation to you when, as Mr. Massey articulated, policy after policy, executive order after executive order issued by President Biden were being rejected by federal courts, subject to nationwide injunctions across the land. Apparently, you were just waiting to come testify in front of the committee to call that a judicial coup d'etat against President Biden. That's what it sounds like.
That's why I believe any kind of nationwide injunction should immediately go to the Supreme Court to be validated as a nationwide activity.
Well, I
don't believe district judges
I understand
have the
that
authority.
alternative. I understand that you've provided that particular alternative as something for this committee to consider. Your written testimony indicates far more significant and structural changes. You referenced the Judiciary Act of 1802 and this notion that the Congress can abolish district courts and the rest, and you seem to be suggesting those as remedies that we ought to consider. In any event, I just want to talk, I know I'll ask the chairman to indulge me since I know he's indulged other members. You have talked about, and I'll just read from an article here, there's a long tradition which has only been broken really starting in the late 1950s with this crazy idea that lawyers and judges are superior to the rest of us and they get to define everything, right?
That's correct.
And you're referencing what case?
Cooper versus Aaron.
Cooper versus Aaron. That case was a desegregation case, right?
Yeah, but that wasn't the point of it.
I understand, but this was a case in which the state of Arkansas was seeking
the ability to not comply with Brown versus Board of Education in desegregating schools in Arkansas. It had nothing to do, by the way, Speaker Gingrich, with presidential power. It had to do with the supremacy of the Constitution and the ability of states to respect the Supreme Court's interpretation of the Constitution. There are a variety of cases long before Cooper in which the Supreme Court has opined on the constitutionality of a president's actions, Youngstown being a great example. It is convenient that for whatever reason you've landed on these 1950s desegregation cases as the inception, in your view, of the Supreme Court's tyranny, as you describe it, I suppose. I don't think that that's consistent with the values of the American people. It's the reason why Republican jurists, Michael Mukasey, a very distinguished federal jurist, as you know, has attacked your ideas in the past. I think you'd concede that. I yield back.
And continued indulgence, I would let the speaker finish.
All I will say is the reference to that is from a book by a liberal lawyer who said specifically that it's Cooper versus Aaron, where, with no reference to the case, the Supreme Court decides to issue a statement that it is clear that we are supreme. And they're not talking about we're supreme over Arkansas. We are the supreme deciders. And that is explicitly false and historically wrong. And it's what Jefferson was so furious about in 1800 because he did not believe judges had the ability to overrule the American people.
I thank the gentleman. We now go to the gentleman from Texas, Mr. Roy.
I thank my colleague from California. Ms. Romero, you have testified about your experience in Aurora, Colorado. As we talked about at the beginning, I came to Aurora and visited with you and others that were impacted by what you were dealing with. To be clear, you felt terrorized in your home, in your apartment. We have an order, Mr. Chairman. Can we?
If you have conversations, please take them off the dais.
Right.
The gentleman's recognized.
With all respect to my colleagues, and I noticed Ms. Romero, who was bothered by, we're talking about people's lives, Americans' lives. Ms. Romero, your life. True, yes or no? In short answer, was your life turned upside down by the existence of Tren de Aragua in your home, in your apartment complex in Aurora, Colorado?
Absolutely, and continues to be.
And people were endangered. American citizens, Americans were in danger.
I was in danger. My family was in danger. I couldn't get my grandchildren to even come visit. It was dangerous over there. The police didn't want to respond. The local government in Aurora did not want to acknowledge. There was continued pushback and gaslighting.
And I mentioned earlier when I opened up this, the extent to which we had a young woman here who was testifying last year in this committee, Alexis Nangre, whose daughter Jocelyn was murdered at the hands of Tren de Aragua members in Houston, Texas. Is that acceptable?
It's absolutely not acceptable.
And so let me ask you this. Should TDA gang members or MS-13 gang members be removed and deported from the United States of America? Let me first ask Ms. Shaw, Professor Shaw, should they be removed?
The president certainly has the authority to make that determination. The question is, how do we know who is a member of these bodies?
So these members should be removed. These TDA gang members, MS-13 gang members who are posing a danger to the American people and citizens should be removed from the United States of America.
I am a scholar. I'm not going to take a policy position on how immigration should be enforced or carried out.
But you comment on these issues all the time.
I opine on the law, and the president has certain authority, significant authority, to enforce the immigration laws, but the Constitution is supreme.
So the president has a significant authority as the commander-in-chief to protect the United States.
Of course.
Ms. Romero, do you think these TDA gang members and MS-13 gang members and other dangerous individuals should be removed from the United States so they do not pose a harm to American citizens?
Every last one of them.
And given that, do you believe it was appropriate for the president to remove those that were removed that Judge Boasberg decided to, from his perch in the district court in the District of Columbia, stop or attempt to stop a plane leaving Harlingen, Texas, to remove said individuals because this judge in D.C. decided to assert that he had jurisdiction over that plane that the commander-in-chief was using to remove these dangerous individuals from our country? Do you think the president was right or the judge was right?
I think the president was absolutely right. If you can describe them as illegal and an immigrant to this country and a criminal all at the same time, they need to go out of our country.
Much has been made of this individual from Maryland. To be clear, this is an individual that by all accounts was a member and affiliated with MS-13, the dangerous gang in Maryland. I will not. This individual was affiliated with MS-13, had an order of removal against him, was here illegally in the United States of America, and was put on a plane, a separate plane, by the way, from the one under the alien enemies removal, because he was on an order of removal. Now, the fact is, I think my colleagues on the other side of the aisle would like the American people to believe that it is more important for us to be concerned about the specific mechanics of an individual illegal alien affiliated with MS-13 endangering the American people, and whether or not the intricacies of due process about what claims that guy was making to alleged asylum. By the way, asylum because he was afraid of what might happen to him at the hands of the gangs he affiliated with if he's sent back home to El Salvador, that would somehow trump the extent to which Ms. Romero or Alexis Nungare would be the ones that are put down at the hands of dangerous gangs, making your life upside down as an American citizen. Do you think that's fair, Ms. Romero?
It is not fair, and I have rights too. And we weren't asked permission to allow these unvetted criminals into our country, and nobody stopped them once we sounded the alarm. Something has to be done now.
Mr. Speaker, thank you for being here. We've talked a little bit about what we might be able to do, and you talked about the fast track to the court and so forth. I remain of the belief, and I think, we've passed legislation out here, and I think it'd be important to send that to the Senate. I agree with you, to send a message to the Supreme Court. I would posit, and see if you agree, I think we need to clarify for the record, for both sides of the aisle, in response to my friend from Colorado's commentary, that we had a wake-up call for our Democratic friends when suddenly there were some judges in the Northern District of Texas who were saying, wait a minute, we don't think some of these ridiculous rulings about men being in locker rooms with our girls in schools should somehow be okay because radical administrators under the Biden administration were allowing it to occur. Do you agree that having a ability to say that you're not going to have a nationwide injunction at the hands of one judge, but then have a process by which you can have a nationwide injunction, either through a 3-judge panel at the appellate or fast track to the court? To clarify for the record, we're saying that's not a partisan exercise, that we're saying that no one judge should make that there should be a process, though, and there are times when a nationwide injunction does need to occur to stop administrators from making law.
The gentleman's time has expired, but you may answer.
Well, whether it is a liberal or a conservative, whether it's a Democrat or a Republican, the very concept of the distribution of power in the American system would indicate that no single person should have the power to dictate to the entire country what they personally happen to believe that week. And I think that we need to demystify the process of judgeship, recognize that it's occupied by humans. There's an amazing passage from Jefferson where he says, look, these are people. They're subject to exactly the same problems as politicians or anybody else, and you can't put them up on a pedestal. So you've got to have a system which blocks power from being exploited by the personality or the idiosyncrasies of one person imposing on 335 million people. And I think that what Chairman Issa has brought out is a very useful first step. As I said earlier, I think the Chief Justice could vitiate this entire issue if he took the right steps. But I think we as a people cannot allow random individuals arrogate to themselves being alternative presidents and imposing their personal will on the entire country.
Thank you, Mr. Speaker. Now you'll back.
Thank you. The gentlelady from Vermont is recognized for 5 minutes.
Thank you, Mr. Chair. Given that Mr. Roy went over by almost 2 minutes, I would like to give the ranking member a minute before I begin.
The gentleman, you yielding a minute to the gentleman.
Thank you. Well, I appreciate that. Thank you to the gentlelady from Vermont. I just want to be clear about this. First of all, I want to align myself with members on both sides who have found your testimony, Ms. Romero, very important and very disturbing. And we all agree that gang members should be prosecuted to the full extent of the law, and if they're here unlawfully in the country, they should be deported. But the idea that that should become the basis for a mass roundup and deportation of people who've never been charged with anything, who have no criminal record, strikes me as absolutely preposterous. And the administration, at least, was willing to come forward to say, okay, they have the wrong person. This was a mistake to have him, but now, c'est la vie, I suppose, he's stuck in El Salvador under a dictator who throws people into a prison that engages in torture. And my colleagues would rather go all the way down to the end of the field with Donald Trump rather than admit that that is a blatant violation of American due process and all of our constitutional values. I mean, that's just extraordinary to me that members of the House Judiciary Committee would be taking that position. That's a very serious problem. Now, Judge Boasberg, who's a conservative judge who was appointed to the bench by President Bush, correctly determined that the Alien Enemy Act of 1798 doesn't apply. It had only been used before in that original Alien Sedition Act period, World War I and World War II. It is for wartime. It is for the deporting of foreign nationals who belong to enemy states, or if there's a military invasion of the country. And it doesn't apply, so he said, we've got to use the Immigration Naturalization Act, but that requires a due process hearing. But that's too much for my colleagues who can evince no sympathy at all for this father of a 5-year-old with autism who has been sent to another country. Now, I don't know, because we're not a criminal court, whether he's done anything, but I do know, based on court records, he has no criminal record. He's not been convicted of anything. And suddenly they're saying, well, he's a member of MS-13. He had an asylum petition, which I'll enter for the record, which showed that he was actually being harassed and persecuted by a criminal gang, which was why he originally came to America. And the court determined, although his application for asylum was time-barred, nonetheless, he has established past persecution based on a protected ground, and he has established the presumption of a well-founded fear of future persecution. So maybe you guys know something about the case I don't know, but that's why I believe in due process, because I think a court should be hearing this. I thank the gentlelady for her indulgence and her kindness.
Absolutely. Thank you, Mr. Chair. I've heard the suggestion from some of our witnesses today that because President Trump eked out a narrow win-in, he should have the right to do whatever he wants with no checks on his power. And I find this deeply disturbing. As a former civics teacher, it feels like we failed somewhere along the way. Presumably, we've all had some basic civics education, and I'm hearing a shocking misunderstanding of how the Constitution works. Professor Shaw, thanks so much for being here. Let's briefly reestablish the fundamentals here. We have 3 branches of government, correct?
Correct.
Executive, legislative, and judicial branch, correct?
Correct.
And under our constitutional order, the head of the executive branch, the president, generally must obey orders by judges, correct?
Absolutely.
And one of the ways Congress oversees judges and the president is through impeachment or removal from office for violating the law or other egregious behavior. Is that correct?
Treason, bribery, other high crimes and misdemeanors, correct.
Thank you. But Congress does not remove judges because of a disagreement with how they ruled. Is that correct?
That is correct.
And why is that?
Judicial independence requires the judges not be constantly afraid that they will be removed from office if they issue a decision that is unpopular or that is, opposed to the interests of the political powers or that runs against the political winds. Judicial independence requires judges to be confident and secure in their rulings and not fear the consequences of those rulings other than reversal on appeal. That's a consequence judges can and should fear, but that really is the primary consequence.
And as you've said, this has a chilling effect. This entire presidency so far is about having a chilling effect on the way that government works. The House must not take up impeachment resolutions based on anything but serious misconduct or illegal behavior. Yet Republicans, including people on this committee who claim to respect the Constitution, have introduced impeachment resolutions against judges because they don't like how judges did their job. They've introduced 7 impeachment resolutions so far. I'm sure there are more to come. Trump and Musk have publicly called for the impeachment of judges that they just don't like. Just by introducing these impeachment resolutions, my colleagues have attacked and weakened the independent judiciary. Does a weakened judiciary, Professor Shaw, endanger Americans' constitutional rights?
The courts are a key guarantor.
The gentlelady's time has expired, but I will give indulgence. You may answer.
I apologize, I didn't see, sorry. I think that an independent judiciary has been and continues to be a key guarantor of all of our rights, and so anything that threatens judicial independence is a threat to all of us.
Thank you, Ms. Shaw. And I will just say in closing, I taught my students for years the Constitution requires that we respect the rule of law and not the rule of one man. Thank you so much for being here.
Thank you, gentlelady. With that, we
Mr.
go to
Chairman.
the gentleman from Texas, Mr. Hunt.
Thank you, Mr. Chairman. Democrats love to talk about democracy. They claim Donald Trump is a threat to it. They say actions taken by his administration undermine it. But let's be clear. Democrats have twisted and weaponized the word democracy into nothing more than a partisan talking point. So let me tell you what democracy is not. Democracy is not the tyranny of the majority. When 77 million Americans cast their vote for a president, and when every major swing state breaks in his favor, and when the Electoral College delivers a clear mandate, it is not democracy when a district court judge overturns the will of the American people and usurps the constitutional authority of the commander-in-chief, full stop. President Trump, along with Tom Homan, CBP, and ICE, are doing an outstanding job securing our homeland. And in just a few months, we have seen historic progress on border enforcement, gotaways are down, arrests are up, and deportations are finally happening. But now we are beginning to see that progress stall. And why? Because of the tyranny of the minority and activist judges targeting immigration executive orders. It is not the role, nor is it the authority of a single judge to undermine the commander-in-chief's constitutional responsibility to repeal an invasion. And make no mistake about it, this is an invasion. 20 million people entering our country illegally for the past 4 years is in fact the quintessential definition of an invasion. It's not just a border crisis. We are fighting cartels like Tren de Aragua and MS-13. You see, groups like these, in coordination with the Chinese Communist Party, are flooding our country with fentanyl. It is not just a crisis here on drugs. It is chemical warfare. And fentanyl is not a simple drug. It's also poison. In my conversations with Texas sheriffs in the front lines, there's absolutely no confusion about what's happening. The mission of these cartels backed by the CCP is simple. And they told me this, and I quote, "Kill the gringo." And that's the reality. And President Trump is using his power and his constitutional power given to him by the American public to stop this from happening. Ms. Romero, thank you very much for being here. Really appreciate your testimony earlier. You went as far as saying publicly that in Kamala Harris's America, every state is a border state and every community is under threat. You also said that after Tren de Aragua invaded your apartment complex, you reached out to local media and several NGOs in your community begging for help, and you were turned away because there were no government programs that grant citizens protected status. I have a question for you, ma'am. Do you feel more or less safe now that President Trump is back in the White House?
More.
And why do you say that?
Because he's getting rid of the criminals that were harassing all of us.
Do you think that President Trump is putting the priorities of America and the average American citizen above the priorities of the cartels and those people that want to destroy this nation?
Yes, because these people were causing immediate harm to citizens, not some imaginary harm that could happen one day.
I mean, if you had a message for the American people today, what would it be?
This is a real threat to our communities, not just mine, not an isolated incident, not just regulated to one building. These are all over the United States. Apparently, people have forgotten 9/11. There are dangerous criminals in our country, and if we don't start getting them out now, then when? After they victimize someone just like me?
I fought for this country. There are many people in this room that fought for this country. I flew 55 combat air missions in Baghdad in an Apache helicopter because I do not want to see animals in our country terrorize my fellow Americans. That's what we took an oath to do. As sitting here in the halls of Congress, it is also our responsibility to protect the American citizen first. For the record, as somebody has deployed all over this world, no other country operates like this. None. You cannot tell me a country that would allow 20 million people to enter their country illegally and their country do absolutely nothing about it. And for the record, this is the greatest country in the world. That's why there's 20 million people trying to enter it illegally. So therefore, we bear an even greater responsibility to keep these animals from entering our country to protect you, the American public. That's our job. President Trump won, and he was given a mandate for that very reason. He promised to protect us and put our priorities first. It is just that simple. I understand my colleagues on the left may disagree with this to a certain extent, but quite frankly, the mandate was already given to us, and ma'am, you're sitting here right now because you are terrorized by the very animals that had no business being in our country in the first place. I'll let you answer this last question, ma'am. As we move forward, what would you like us to do to protect you?
Briefly, please.
Stop wasting tax dollars trying to interrupt him and stop him from what he's doing. Do something to protect the people who elected you and put you in your spots. To look down and decide what happens to the rest of us.
Thank you, ma'am. I get back to the remainder of my time.
Gentlelady from North Carolina, Ms. Ross, for 5 minutes.
Thank you, Mr. Speaker, and thank you to the witnesses for being here today. This is an extremely important issue for our country and for the future of our country. But let me be clear before I ask my question. Donald Trump's contempt for the judiciary is not new. He has fought civil cases against him because of real estate deals and people he hasn't paid. He's fought victims that he has sexually assaulted and he has been convicted of sexually assaulting. His disrespect for the judiciary is based on his disrespect for anybody who doesn't let him do whatever he wants, whenever he wants. And he is very dangerous right now because he is the President of the United States of America. And we are seeing him treat the people of the United States of America the same way he treated those poor contractors he never paid, the same way he treated women who he sexually assaulted. He is doing the same thing to the United States of America. So, Professor Shaw, on February 9th, Donald Trump told reporters that no judge, quote, should be allowed to rule against his administration's unconstitutional changes to how our government operates. And the next day, Vice President J.D. Vance posted on X, judges aren't allowed to control the executive branch's legitimate power. Just to be clear, does the president decide what issues judges get to rule on under our Constitution?
No, really, since, Marbury versus Madison, 1803, judges and the Supreme Court, right, sitting at the top of the federal judiciary, have had the final word on the meaning of the Constitution and the laws and the consistency of laws or executive action with the Constitution. So in our system, it has been the courts and not the president who have had the final word.
Thank you for that. So I am going to quote Fourth Circuit Judge Michael Ludig, who I can testify, no liberal. I had a case in front of him. He was a tough customer in the Fourth Circuit. He was appointed by George H.W. Bush, and he recently noted in an op-ed for the New York Times, quote, "A country without an independent judiciary is not one in which any of us should want to live, except perhaps Mr. Trump while he resides in the White House." Trump has railed against the federal judiciary for years, as I said in my opening, and especially now that his administration is losing in courts nationwide. So, Professor Shaw, what could Congress do to stand up against Trump's attacks on the judiciary to ensure that it remains functioning, independent, and co-equal in our system of governance?
Well, I certainly don't think resolutions of impeachment, for no other reason than rulings that members disagree with, are constructive from the perspective of preserving judicial independence. I mean, one thing that I would imagine that bipartisan support could easily rally behind is judicial security, right? We are in a moment in which we have read about the U.S. Marshal Service concern about heightened levels of threats to federal judges. When there was an actual threat against Justice Kavanaugh in 2022 on a bipartisan basis, security for Supreme Court justices was increased. But I'm not sure that we've seen anything to that effect now. So shoring up judicial independence at a moment where, frankly, there are not a lot of other functioning checks on the executive branch is, to my mind, critically important. And maybe that's one way this body could devote itself to doing that.
And then going back to the impeachment issue that my colleague from Vermont discussed, if Trump is successful in getting judges impeached in the House, I don't think he would be successful with the final decision in the Senate. Is he allowed to demand that a judicial nominee promise not to rule against him or his administration under his appointment power?
There's nothing in the Constitution that speaks to that one way or another, but it is certainly a very established tradition, bipartisan and longstanding, that presidents do not secure commitments, in particular with respect to particular rulings from nominees they are considering. Certainly the Senate, in its advice and consent role, could seek to enforce that longstanding principle by asking nominees if they have been, asked or have given any kinds of assurances, but it would be wildly inconsistent with our practice for a president to seek such assurance from a nominee.
Thank you, Mr. Chair, and I yield back.
Gentlelady yields back. Does the ranking member have a unanimous consent request?
Thank you very much, Mr. Chairman. This is from March 31, 2025, the makeup artist that Donald Trump deported under the Alien Enemies Act from The Atlantic.
Without objection, so ordered. The gentleman from Texas, Mr. Gooden.
Thank you, Mr. Chairman. Ms. Shaw, earlier you said that you worried that some of the intent of these actions will have a chilling effect to disincentivize the taking on of clients, and that the legal system we have requires lawyers to take on unpopular clients. Would you expand on that, please?
So, lawyers, the idea that even individuals charged with crimes are entitled to counsel and to vigorous representation in their defense, regardless of what they may have done, is actually a core kind of belief pillar of our legal system. And so that's one example. Individuals, even charged with serious crimes, have a right to counsel.
So I guess one of the things that I struggle with is after the 2020 election, one of the groups that comes to mind is the 65 Project, which is a legal activism campaign seeking to disbar and discredit Trump-affiliated lawyers who worked on lawsuits supporting Trump's attempts to question the 2020 election. They're a dark money group, and I don't recall my colleagues or you speaking out against this. And in fact, there were attorneys that were disbarred for representing their client. Now, sure, there's folks in this room that didn't agree with them, but one of the things you said during that time was, quote, there need to be serious social, professional, and reputational kinds of sanctions if we want to disincentivize this kind of conduct. And I think this kind of conduct is perhaps taking on a client that supports a belief that maybe is not popular. And I really hope that we'll get away from this lawfare. And that's something that was prevalent over the last 4 years throughout this campaign, and now we're seeing it from this judiciary. And I'm disappointed in this judge, but I am happy we're having this discussion, and I'll yield the balance of my time to Chairman Jordan.
Oh, I thank the gentleman for yielding. Some of the previous speakers on the other side have said, members on the other side have said, attacks by President Trump, I think I got this right, attacks by President Trump on the judiciary are dangerous. They said criticism of judges weakens the judiciary. Mr. Larkin, have Democrats ever criticized the judiciary?
Yes, sir.
Can you give me an example that maybe comes to mind? I mean, I have several, but I want to know what's one that comes to mind for you?
Well, I guess the best example and recently was the Supreme Court's decision in Dobbs to overturn Roe versus Wade.
Yeah, where like hundreds of churches and pro-life centers were attacked and firebombed and got all kinds of criticism coming from people that have. How about this one? How about the minority leader in the Senate said, I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you've released the whirlwind and you will pay the price. How about that one? You remember that one, Speaker Gingrich, from Senator Schumer?
Well, I think it's fair to say that the passion of the left when the court does the wrong thing probably is more professionally organized than any passion on the right. But look, I mean, Franklin Roosevelt tried to pack the court. He was a Democrat. There's a long tradition in America that we're allowed to argue over. The courts they're not temples. This is not a religious judicial system. It's a secular judicial system.
Yeah, fair enough. And look, we're going to criticize decisions all along. We're getting it one way. This goes both ways. Both sides have criticized the courts, criticized decisions. We're allowed to do that in this country. That's the way it works. Professor Shaw, do you think it was appropriate for what Mr. Schumer, Senator Schumer, said on the steps of the Supreme Court when he said you will pay the price, referencing two members, sitting members of the United States Supreme Court?
I think he should have phrased it differently. I'm sure he feels the same way.
What about the Dobbs leak? What do you think about that and some of the comments that were made after that decision was leaked? Do you think that was good?
I'm not sure what comments you're talking about. That there were very, very sharp criticism of Justice Alito's opinion in Dobbs. I think that's perfectly healthy, yes.
I think we had a member said that there should be impeachment for the decisions that happened after the Dobbs decision. There should be impeachment of one of the Supreme Court justices. A member of Congress said that. Do you think that's appropriate?
Impeachment rhetoric is something that we have seen from time to time. I guess I'm not categorically opposed to talking about it. I think introducing resolutions, as we've seen, has been a significant escalation. And of course, it would depend on why. I think there was serious discussion of impeachment of several sitting Supreme Court justices over ethics matters in the last few years. I don't think there's anything unhealthy about those discussions.
It's okay to talk about impeaching Supreme Court justices. It's okay to add 4 associate justices to the Supreme Court, and you had no problems with the comments made after the Dobbs leak. Is that your testimony?
I'm sorry, I'm not sure what specific comments you're talking about, but criticism of the substance of the Dobbs ruling, I have no problem with that.
Okay, I yield back.
The witnesses have been very kind, and there are more people that want that kindness. So with that, we'll take a 5-minute recess. take our seats. We've been informed that we're going to have a vote in about the next 15 or 20 minutes. And Mr. Speaker, with the exception of the Speaker, all of us have to go vote like Pavlovian dogs. We will drool otherwise. I think you probably wrote about it, Mr. Speaker. Committee will come to order. We now recognize the gentlelady from California for 5 minutes.
Thank you, Mr. Chair and Ranking Member. You know, the student tours have started back up here in the Capitol, and I was walking through the rotunda. I walked past a group of young kids from Ohio, and the kids were listening to their teacher talk about George Washington, and then I heard the teacher say that this is where we have all of our checks and balances. And I remember thinking to myself, well, only for a few months more. And you talk about banning books. I was like, well, we might have to ban all of the books that talk about checks and balances because we won't have any at the rate this committee is going. So in fourth grade, children are learning about civics, the three branches of government, the checks and balances of power between the different branches, the co-equal partnership between the executive and legislative, the independence of the judiciary. Not a new phenomenon. Article 3 judges were established 236 years ago in the Constitution with the lifetime tenure. And we could go back, and I've heard it in this committee, and talk about Marbury versus Madison, Plessy versus Ferguson, Dred Scott, but more recent is where I want to land. And I thank the chair for also bringing up some of these rulings. We've had Bush v. Gore, we've had Citizens United, we've had Hobby Lobby, we've had Masterpiece Cake Shop, we've had the overturning of Roe v. Wade. And yes, all major wins hailed by the right. And in the aftermath of these rulings, even with the passion of the left, Mr. Speaker, the judicial institutions remained intact, and bench officers were not excoriated or physically threatened. In fact, one U.S. district judge, her son was killed. But now we have an administration aggressively and unapologetically pushing the boundaries of what is constitutional and erasing the checks and balances of power by going after judges who do not side with Trump, to the point that even Justice Roberts of Republican lore says it is inappropriate to impeach judges. And after all, he is part of the ultimate arbiter in this arena, which favors the Republican Party with a 6-3 majority. So I'm asking myself, what is really going on? What is going on is we are setting a dangerous precedent by replacing judicial independence with judicial fealty. Because if judges feel like they must follow a partisan ideology rather than independently interpret the law, then we, as lawmakers, are a shill in this charade. We do not make laws for ourselves to interpret. We make laws for judges to interpret and impose punishment to those who don't follow them. And what is sad is that all these decisions that Trump doesn't like are still appealable. So once again, what is going on? What is going on is, instead of being a party that supports smaller government, Republicans are creating a far-reaching leviathan, an insatiable, chaotic monster of power. And once that locomotive starts going, you cannot put the brakes on. This judicial independence, checks and balances have withstood 118 Congresses and 46 presidencies. And somehow today, we are supposed to be at some critical moment where we are told to believe we have to blow this thing up. And it makes me think about March Madness, which is happening right now. These kids are playing their hearts out. They are trying to win, and they are dealing with good calls and bad calls from referees. And not all calls are perfect, but they are still respected. No one says, I didn't like that call, go after the referee, go after the system. And in fact, in organized sports, the most classless and unpalatable thing you can do is blame your loss on the referee, or blame the umpire for the outcome of the game, or cheat. And 5-10 years ago, we saw these parents attending these Little League games, and then violence was being committed. People were running onto the field, attacking and assaulting the referees, and it was distasteful. And now we are here with this court doing the same thing. The games do not work without officials, and our system of justice does not work without judicial officials. And Justice Roberts says, all we do is call balls and strikes. Judges, like referees, are a neutral party. You don't always like what they say. You might not always agree with their calls, but you have to respect the institution and the officials. And if you take away the one element that brings integrity with it, then the competition itself has no integrity. And then you have to ask the question, why do we even take an oath? Why do we even obey any of these laws? And what we have right now with this hearing, with Trump's attack of the bench officers, with the threat to impeach judges, is the equivalent of parents rushing onto the field and trying to punch a judge in the face. It is disrespectful, it is unseemly, it is unprecedented, and it is a disgrace. And with that, I yield back.
I thank the gentlelady. We now go to the gentleman from California for his 5 minutes. Mr. Kiley.
Thank you, Mr. Chair. In our state of California, we have a governor who routinely attacks judges when he doesn't get his way, often in very harsh terms. This being Governor Newsom, of course. After one ruling related to the Second Amendment, Newsom threw a veritable temper tantrum, calling a special press conference to lambast the judge, calling him an extremist, a stone-cold ideologue, a wholly funded subsidiary of the NRA, and saying, quote, "We need to call this federal judge out. He will continue to do damage, mark my words." So it is curious hearing some of the comments about the appropriate relationship between the branches, different branches of our government, and the appropriate way to opine on judicial opinions with that in view. And we've also, of course, seen examples brought up by Chairman Jordan related to Chuck Schumer's comments on the steps of the Supreme Court that were rebuked by Chief Justice Roberts himself. So there certainly is, I think it's appropriate as elected officials for us to express views on opinions of the judiciary, but the idea that one side has crossed a line but the other has not simply is not borne by the evidence. Now, the broader question before us today, I think, is related to this issue of checks and balances, because I think we've reached a point where checks and balances have gotten a bit out of whack, given developments that were not really on the minds of the founders related to the idea of nationwide injunctions, which didn't exist in the early years of the Republic, or really not until modern times. And given the expansive growth of the federal judiciary, such that now you have not just an issue of the judiciary impeding the president or impeding Congress, but rather you have the ability of any individual judge to do so. As Justice Gorsuch has said, the government's hope of implementing any new policy could face the long odds of a straight sweep, parlaying a 94-0 win in the district courts into a 12-0 victory in the courts of appeal. So what these nationwide injunctions have effectively done is not just shifted power from one branch to another, but empowered the most extreme people within the judicial branch by saying that we're going to give one judge who can be essentially picked by the plaintiffs the ability to put a policy on hold. And what this creates is a sense of stasis, and I think a sense of frustration. And you see this during Republican and presidential administrations, that the levers that we have to really have our citizenry exercise its will are getting increasingly difficult to pull. You know, we have increasing hurdles to legislation, the ability to get over a filibuster in the Senate to change policy that way. And then even when the president is exercising his duly granted authority, we have these nationwide injunctions that are putting the president's agenda into stasis. And so I do think there is an appropriate opportunity here to see if we need to recalibrate the way checks and balances are functioning. And I think that on top of that, it's a matter for the judiciary itself, because the way our system generally works is you have different forums, you have different cases addressing similar issues involving different fact patterns, you develop a factual record, you have different judges that provide a different sort of analysis, and then to the extent that they conflict, it percolates up the system. You have that record in place, and you can then come to a decision that has the most fully considered process, that within our system. And these nationwide injunctions are short-circuiting that entire process, not allowing for the merits of an issue to be duly considered, and simply giving one particular judge, often on the extreme end of the distribution, full say on the matter. So, Mr. Gingrich, Speaker Gingrich, you've mentioned a few possible remedies here. One that caught my attention was the ability of the Chief Justice to establish a procedure as it concerns nationwide injunctions. What would that look like?
Well, thank you, Raj. Look, it would be the least intrusive and least disruptive to have the Chief Justice decide, and the court decide. It would be very simple. Yes, a district judge can render a judgment, but the moment he or she renders an injunction beyond their district, the Supreme Court would immediately intervene, suspend imposition of the remedy until the Supreme Court rendered a decision. If the Supreme Court said, you're right, then you have a Supreme Court enforced nationwide injunction. But if the Supreme Court said, you know, we're not convinced, then it would vitiate the whole thing and it would be over. And you would not have the ability of individual district judges to make radical decisions. Remember, justice delayed is justice denied. You start having, and this is where frankly, the Chief Justice was, I think, a little bit silly, to say, well, there's an appeals process. If you're talking about getting rid of criminals, or you're talking about defending the country, an appeals process can run so long that the damage has already been done by the time you go through the appeal. And so I think in some form, if we're going to retain the ability of district judges to issue any injunction, it has to be modified. If we can't get a modification, it has to be abolished.
Thank you very much, and I would encourage the Chief Justice to hopefully be thinking about this from his perspective. And in Congress, we of course also have tools to create expedited appeals, and I think that frankly, that's hopefully perhaps a compromise that both sides could come to, since this will be an issue that arises in future administrations as well.
I thank the gentleman. I now ask unanimous consent that Ms. Crockett be permitted to participate in today's hearing for the purpose of questioning a witness if a member yields time for that purpose. And without objection so ordered, I now recognize the gentleman from California, Mr. Swalwell.
We're about 2+ hours into this hearing, maybe 3, and as I'm taking stock, we're here because some guy I've never heard of, he might be in Congress, introduced an impeachment resolution, but he's not here. He hasn't been here for at least the last hour, and every witness here is in agreement that we really shouldn't be impeaching judges. I haven't heard a single colleague on the other side say we should be impeaching judges.
Would the gentleman yield?
Not yet. And this guy's just raising bucks on this issue. This is like a fundraising ploy, but we all are here, like we're in our suits, we're wasting, or we're not dedicating ourselves to other matters because this guy wrote some article. It just seems kind of absurd to me because no one even thinks that's the remedy. And I dare, whoever this person is, I hope he would come, I dare him to bring a privilege resolution because we could actually debate this, but it's just a stunt. I promise you, it's a stunt. I will contribute to his campaign if he brings before this committee an impeachment resolution. Now, Speaker, you said some of these judges are pretend presidents,
how much would the gentleman give to his campaign?
700 district judges that are pretending that they're president. There's a single judge in a federal courthouse in Amarillo, Texas, where conservatives are form shopping and having cases sent to him, Judge Kaczmarek. In 2023, he suspended mifepristone approval. That's a medical abortion pill. Can you direct me, Speaker, to the statement you gave objecting to him doing that? I couldn't find it.
No, I haven't spoken out on this issue until I was invited to come here.
Okay.
I wrote about it in 2011, and I submitted that for the record.
How about when Judge Kaczmarek ruled against ACA protections for LGBTQ individuals in November 2022?
Well,
Did you speak out against that rogue judge?
I think the term "I have not spoken on this issue until I was invited here" was generic and included every single one of the cases you want to ask about. So I will stipulate in advance I did not comment because I did not comment. And I'm not here to comment on a single case.
How about an
I'm here to
election?
say-
Okay, I
I'm
got
here
it.
to say that the system is out of whack.
Speaker-
Which, by the way, I wrote about in 2011.
An elected Trump third term, is that constitutional? I think it's funny too.
If the Congress wishes to pass a constitutional amendment and the requisite number of states decide to endorse that amendment, of course he would have the option to run for re-election. In the absence of that kind of constitutional change, I think that it's impossible.
Thank you. And with that, I'll yield to the gentlelady from Texas, Ms. Crockett.
Thank you so much, and I appreciate the speaker for admitting openly on the record that it is unconstitutional. But the concerns that I have are around the fact that we are sitting here pretending as if we all are looking out for the Constitution, yet we are coming from completely different angles. So let me go to Professor Shaw. To be clear, which branch of government is responsible for interpreting what is and what is not legal?
Well, the Supreme Court, the Article 3 judicial branch has the final word.
So the judiciary is who it is. So it's not the legislators.
You know, I'd say every branch has an obligation to interpret the Constitution. The final word comes from the courts.
From the courts. It's not the former speakers. It's not everyday people. It's not the president. I just wanted to make sure that we understood who it was that was responsible. And what is so frustrating for so many of the American people, the ones that are watching right now and otherwise, and the reason that they're outraged and scared is because what we see right now is a diminishing of all these institutions. Right now, we have a legislative branch that has decided that it intentionally would disregard their duties. They are not checking the president whatsoever. The only check that the American people have had thus far has been from the judiciary. And the judiciary isn't pulling this out of the sky. In fact, they are coming from basic reading of like the plain language of the Constitution for all of those that are constitutionalists when we start talking about things such as what birthright citizenship is. But one of the things that I want to make sure that I get to, because there are deeper implications if we go down this rabbit hole. Imagine the type of world where the president does whatever he wants to and no one can rein him in. It's a world that right now many people are afraid of. Let me put it this way. If Joe Biden would have done an executive order for abortion, despite what the Supreme Court said, that would have been a problem. Imagine if the state of Colorado kept Trump off the ballot and other states follow suit. That would have been a problem. Or imagine if Jack Smith ignored Eileen Cannon and with the help of an activist judge decided that he was going to prosecute the sitting president anyway. The problem that we have right now is that if we continue down this road, then we will not have a rule of law because we have people that are currently serving and they're saying things like, ignore the judge's order. What it means to have law and order in this country is that you follow the order and you go through the appeals process, even if you dislike what the judge did. Thank you, and I yield.
And I'll yield back to Mr. Issa.
Yep.
Mr. Issa, you had a question for me, which I'll yield to you now if you want to.
Now that there's no time left. Thanks, Eric.
Entertainment.
You're good. You're good at that, but I'll take my own time. I'll recognize myself. And I'm going to note that when Ms. Ocasio-Cortez, or AOC as we know her, filed articles of impeachment on Justice Thomas and Alito, Ms. Crockett was one of the co-sponsors along with Mr. Cohen, both members of this committee. It does seem interesting that when the shoe is on the other foot, everyone is self-righteous. And I think this is a good example. For the last
Mr.
3
Chair,
hours, I have had to listen to one side talking about impeachment as though it was the nature of this hearing. It is not. I keep looking at my friend, the late Henry Hyde, and remember that although he led the impeachment when it was necessary, he did so only during that time and then never mentioned it again in hearings. In fact, he was religiously able to focus on the hearing of the day. The hearing of today is really about the question of the future of the court's ability to do its job as intended. And I'm going to get into a couple of things fairly quickly. Last night, a California judge, Judge Chen, proactively stopped the ending of these temporary protective status. So the very person that they're talking about, who is now apparently back in his home country of El Salvador, can no longer be sent there because a judge has decided in California to stop an action which was done completely by one president at his discretion, and when another president says, I'm ending it at my discretion, they stop him. So I'm going to go to Mr. Larkin first. You mentioned earlier on Alaska, I think, in passing about judges in various places, and I'll reiterate a question that Speaker Gingrich also answered earlier. If one judge can take a case before them and make rulings on behalf of plaintiffs not there, and yet it's a district court judge, and we know that courts around the country routinely take similar cases with different plaintiffs and decide them differently, and that's how we generally get to the Supreme Court, is to resolve those. Is there any reason that this administration couldn't file a declaratory judgment, not in California where Judge Chen ruled, but in some other place, let's say Texas, which has been mentioned today, and get a different outcome, and in fact undo and give in fact the administration a legitimate right to say, no, we've been found not to be enjoined, but we have a right to do it as long as we siphon it through Texas instead of California. Is there any reason today that that doesn't exist as a problem of these national injunctions which are not in the jurisdiction of these judges?
What you're talking about is a problem that the Supreme Court contemplated when it decided the Mendoza case some years ago. It recognized that different courts will decide issues differently, and it decided not to bind the government the first time it lost. If the government lost in Maine, it could continue to take the same position in Alaska or in the other states. They were asked to basically adopt a one-and-done rule, and the Supreme Court rejected it. So it's permissible under the law.
So when people talk about this president acting illegally, the fact is this president, by acquiescing to these and going through the appellate process, actually is going further than he has to under the Constitution. The reality is he could simply say, you made your decision, we just won't do it in your district, but we'll do it elsewhere, and we'll seek other remedies in other areas. So the fact is, this administration has been overly generous for this first 70-some days, correct?
The Supreme Court in Mendoza was unanimous. It included conservatives and liberals on that court, and they allowed that development
So under
to occur.
Mendoza, the fact is only the Supreme Court speaks for the entire nation, and that is what we are discussing here today. It's the issue before us. Is that correct?
Yes, absolutely.
Okay, I'm going to just derive a couple of other quick things. There was an earlier question on Rule 65.
Mm-hmm.
Now, these are produced by the court, and the unambiguous language of it says that, in fact, at least in some cases, we won't argue over any one of these now approaching 100 cases, there has to be a bond, and yet there have been no bonds. Is that correct?
I have not searched the record in all those cases, so
We have. There hasn't been a bond.
I'll trust you on that.
So Rule 65 is being ignored by these activist judges, and as a result, there's a real question about, in disobedience of those rules, in absence of a bond, they may in fact not be enforceable as valid, correct?
That may be. I would not say they've been ignored, because if they weren't raised by the government as an issue in the case, then they might have just been overlooked. So
I would trust that from this day forward, they will not be overlooked. You've got enough time. This will be the last round until the recess. You're recognized.
Thank you. Thank you very much, Mr. Chairman. Mr. Gingrich, I want to focus on some of your testimony today. You say that a judicial coup d'etat is being implemented by judges of the same political ideology. In another statement, you said that Judge Boasberg has a clear bias against President Trump. Do you know who appointed Judge Boasberg?
I think his first appointment was by George Bush.
Correct. And we've been talking about nationwide injunctions. There's been a lot of discussion about the injunction on the president's birthright citizenship executive order that was enjoined by Judge Kuenhauer. Do you know who appointed Judge Kuenhauer?
No, I don't.
Ronald Reagan. So let's just focus on these two Republican-appointed judges so we can just remove all the allegations of partisan bias.
So we're removing the other 90.
So let's focus first on Judge Boasberg's case, which is the Alien Enemies Act of 1798 law that very specifically applies during wartime or if the country is subject to an invasion. Now, you would agree, I assume, as a former Speaker of the House, that it is Congress's duty to declare war.
I think there's also a provision of that act which does say for invasion, and I think the average American will tell you they feel that we've been invaded by the policies of the Biden
So the average, so are we now supposed to say that your assessment of the average American's view determines whether or not we are under invasion by Venezuela? So that's what we're supposed to do. Now, is it, if not the average American, what your testimony is here today is that Donald Trump, because he was elected president, alone should determine whether or not that law applies without any due process. Is that your testimony?
No, my position is that the Supreme Court should have the opportunity on a nationwide issue to render, but remember.
Okay, so let me reclaim my time. So basically what you're saying then is the problem here is that Judge Boasberg pre-certified a class because, of course, it is the exact same legal question for every single person who was removed to El Salvador. And what really should happen is that every single one of those people should have to file their own lawsuits. And each district then judge should rule on it. Because that's the difference, the opposite of a nationwide injunction, right?
Actually, as I've said several times in the last 3 hours, there can be a provision by which the Supreme Court takes up that injunction.
So which is it? Do you oppose nationwide injunctions as a judicial coup d'etat?
No.
Or do you think nationwide injunctions are appropriate in certain circumstances but should have expedited appeal?
I believe that nationwide injunctions by an individual judge is far too much power, and that there could be a procedure.
Let's keep on with Judge Boasberg's case, okay? So he issued, and by the way, he did not issue an order on the underlying issue. He temporarily enjoined the president from whisking off people to another country without due process so that the legal issue could be resolved. Now, you say expedited appeal. That opinion, that case was already appealed to the district court, the Court of Appeals for the district court. They've already ruled. And by 2-1, they kept the temporary injunction in. It was a Republican appointee, Judge Henderson, who was one of the two. So I guess I'm confused as to what the problem is with a temporary nationwide injunction so that the issue can be resolved, and if necessary, ultimately by the Supreme Court. It sounds like you agree with me that that is the appropriate process.
The difference is whether or not you believe, one, that time matters, and
well, this was within a matter of weeks. It's now up before the Supreme Court. That's expedited, and I will say, I wholly agree with you, and to my colleague, Mr. Kiley, I would happily work to expedite appeals for nationwide injunctions. I hope my Republican colleagues would work with us to expedite enforcement of congressional subpoenas. The courts take far too long. I agree with you. But the notion that we do not have due process and that someone should be removed without due process based on false pretenses, which the administration now admits under a petition for habeas corpus, I would add, Mr. Larkin, and that there's no recourse because their mistake is now out of their control, I think even you, Mr. Gingrich, would agree with me that when you mistakenly accuse someone of being a gang member and you deport them, that it is incumbent upon you to fix that mistake. Do you agree?
I agree.
And with that, we're going to give you at least until, let's call it 2:30 to return. We stand in recess. You're next. Thank you all for your patience and indulgence. It took a little longer than we planned. The committee will now resume, and our next questions will come from the gentleman from North Carolina, Mr. Harris.
Thank you, Mr. Chairman. Thank you all on the panel for your patience today and continuing to persevere as we go through this day. Speaker Gingrich, you've referred to this trend we're discussing today as a, quote, emerging dictatorship of district court judges, end quote. And you posted on X that the No Rogue Rulings Act, quote, would be an appropriate first response to the district judges who are trying to be mini presidents totally beyond their constitutional authority. I totally agree with you, Speaker Gingrich, and the No Rogue Rulings Act would be an impactful first step in addressing this problem. I was proud to vote in favor of it when this committee marked it up, and I later joined on as a co-sponsor and look forward to, at some point, having the opportunity to vote on the House floor. But Speaker Gingrich, specifically, do you believe there are any additional legislative steps that need to be taken to address the problem of activist judges acting beyond their constitutional authority as you described in your post?
Well, I would just say for the moment that this issue of district judges becoming alternative presidents and issuing nationwide injunctions is such a central point to where we are, that solving this, first of all, if we can successfully limit the district judges, we will have sent such a strong signal of rebalancing the Constitution that I think it will sober up everybody in the judicial side. I mean, in the future, there are some key issues. The whole notion of whether judicial supremacy means supreme inside Article 3 or supreme over Article 1 and 2, I think is an issue worth taking up. But I would put that at a very distant second to solving this immediate problem, because if you solve the immediate problem, you both make it possible for the executive branch to be effective, and you've sent a pretty powerful rebuke to the judicial branch that they can't overreach in what they're doing. So I would make it a sequence in that sense.
I got you. Well, as we all know, President Trump issued an executive order 14160, which was referenced earlier today, in ending birthright citizenship for children born to illegal immigrants or those on temporary visas. It was on February 5th that U.S. District Judge Deborah Boardman of the District of Maryland issued a nationwide preliminary injunction against this executive order, arguing that it ran afoul of the 14th Amendment. Speaker Gingrich, do you think it is in line with the president's duties to re-examine birthright citizenship as he did with Executive Order 14160?
Well, I mean, it's certainly a legitimate function of the presidency to look at how things change and how they evolve. I suspect in the short run, this will be resolved at the Supreme Court level. And I personally believe that it's pretty hard to go back and look at the debate at the time of the 14th Amendment was adopted and somehow leap from that to a birthright situation. And in fact, they're fairly clear, for example, that people who are born to diplomats in the United States do not count as citizens. And there are other factors there, but I think the next phase of that argument is going to be at the Supreme Court level. And then I think, depending on what happens, you know what, we live in a very different era. The scale of illegal immigration, which frankly has changed. My guess is some of these debates will change pretty dramatically because President Trump is being so stunningly effective at controlling the border and pretty effective at going after illegals who are also criminal. But I do think in the long run, having somebody who deliberately comes in the U.S. just long enough to have a child, and then having had the child, maybe on a tourist visa, if you will, claiming now they have an American citizen in their family. My guess is, to the degree that that continues to evolve with modern transportation, that we'll probably revisit this issue, but first we ought to see exactly what the Supreme Court says.
All right. Thank you, sir. Mr. Chairman, I yield back.
If you'd yield to me.
I'll yield to you.
I'll follow up on that briefly. So a diplomat's child is not a citizen, correct?
Specifically correct.
So a diplomat is here on a visa and is lawfully in this country, including the spouse, typically. would an invading armies that comes with its spouses, well, here occupying, let's say, Texas, would their children be covered under the 14th Amendment?
My reading of the debates about the amendment would suggest that you had to be here legally in order to be qualified to have a child who would become an American. See, you couldn't be here illegally. You couldn't be here in a situation where you would not be within American law. And I think in that sense, an invading army by definition is not here as part of the American law.
So it's a legitimate debate on the 14th Amendment
Yeah,
and
no,
where you'd be in and out.
I think it was a habit which grew up sort of absent-mindedly when there frankly weren't very many cases. And as it got to be a bigger and bigger issue, people began to say, wait a second, do we really think that in the 1860s, this is something they had in mind? And I think it's pretty hard to read the debate and conclude that they wanted birthright citizenship for non-citizens.
Yeah. So now we go to the gentleman from Missouri next.
Excuse me.
Oh, I'm sorry.
Thank you.
Oh, you haven't gone yet?
No, I have not.
You sit so close.
I know.
The gentlelady is recognized for 5 minutes.
Thank you. It's interesting that we've returned to the birthright citizenship argument because I think the courts that have looked at this issue, several courts already, and have reviewed the debates from that time, found that they did explicitly consider the issue of non-citizens and who was in the country, and the court has considered it as well. But I think, Mr. Raskin, I could yield to you for a minute.
Well, thank you, Ms. Scanlon. I've looked at this question too. I've gone back and I've read the debates. All of the explicit mentions I've seen were explicitly to reject the proposition that Speaker Gingrich just mentioned, the idea that somehow you wouldn't be covered. There was an exception talked about for the children of diplomats, but that was very much a discrete exception everybody identified. And one way of understanding this, of course, is that the African Americans for whom the first sentence of the 14th Amendment were core intended themselves all had parents and grandparents who were non-citizens, because the meaning of the Dred Scott decision was that you could never be a citizen if you were an African American or the descendant of slaves. And so the first sentence of the 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof shall be citizens of the United States, was a direct overruling of Dred Scott and saying that all of these people whose parents were not citizens could come in. And there were specific questions on the floor about people from other countries, especially what were considered the Dread Chinese at the point. And there were very emphatic statements made that, yes, even the children born of Chinese non-citizens would be citizens. So I'm not quite sure what the speaker is referring to. If you've written a law review article on that, I would love to see it. But everything that I've seen, both directly in the debates and the law review literature, is completely counter to what he just said. Thank you for yielding.
Thank you. The committee's covered a lot of ground today, and I just wanted to return for a minute to some of the basic civics principles that were raised by this hearing and why our courts and an independent judiciary matter. Some of our colleagues and the administration itself have suggested that since Donald Trump won the 2024 presidential election, his actions and his interpretation of the law can't be questioned. Can you explain why that's a problem under our constitutional system?
Sure, I would say that sort of maybe the single most important core structural principle in our Constitution is that power be divided and that power check power, because too much concentration of power leads to tyranny. So all that we have seen with the rulings that have come down that have found violations of either statutes passed by Congress or provisions of the Constitution is the separation of powers working as intended. So the president having the sole and final authority to determine the meaning of laws, statutes, or the Constitution is just fundamentally inconsistent with the notion of separated powers that is, I think, the core of our Constitution.
I think we've also had conversations today about due process and how vesting all the power to determine what the law is and who is subject to it in one person or one branch leads to a slippery slope. We've heard today that the administration has deported someone who was not a Venezuelan gang member and in fact did not even have a criminal record. We know that in the past, the administration has deported citizens because they were not able to get a hearing to prove they were citizens. So this slippery slope becomes very real. Nobody here is saying that we shouldn't punish or deport violent criminals, but we are saying that you need to prove someone is a violent criminal before you can exert this kind of punishment on them. Can you talk about how that impacts every American?
Sure. Yeah, I mean, I just think that the only way that government can be sure and that all of us can be sure that they are targeting the right people for these harshest of punishments is by affording a modicum of process, right? That is the notion of due process. So making sure that individuals understand what is being alleged against them and have some opportunity to respond, that is just the heart of due process. And I do think that it's important that both the initial temporary restraining order issued by Judge Boasberg, that we've talked about a good amount already today, that was affirmed by a panel of the DC Circuit that included appointees of both Democratic and Republican presidents, simply sort of reaffirmed that core notion that a degree of process needs to be afforded to everyone. And that's not to constrain the ultimate ability of the president to enforce the immigration laws. It just suggests the Constitution needs to be honored while he does that.
I want to thank our witnesses. I'd yield my remaining time to Mr. Raskin.
Thank you. It seems to me that when Donald Trump was criminally prosecuted in New York or civilly sued in New York, everybody insisted on all due process, and he deserved it, and he got it. And even then, people still doubted the integrity or the veracity of some of the findings and the verdicts. And now we have people saying, no, we don't need any due process at all in order to, do X, Y, or Z to someone, and that just can't be right. Thank you.
Thank you.
We go to the gentleman from Missouri now.
Thank you, Mr. Chairman, and thanks to all the witnesses for joining us today. Speaker Gingrich, thank you for your testimony. You are a great student of history, in fact, a great teacher of history. And I'd like to recall the words of Chief Justice John Marshall, who famously said it is emphatically the province of the Judicial Department to say what the law is. I've never liked that quote because on its face it implies some sort of judicial supremacy, that judges are somehow supreme oligarchs, that they are like Moses bringing down the tablets from Mount Sinai. But I think Marshall at the time was presiding over what was famously called the weakest and the least dangerous branch of government in Federalist 78 by Alexander Hamilton. And I think Marshall, if he were here today, would say that, yes, the judges are the ultimate interpreters of what the law is, and of course it is the duty of the judges to apply the law in concrete cases before them. But we face a very different situation today. I believe we do have a constitutional crisis, as you say, a judicial coup. We have Chuck Schumer bragging about his 235, quote, progressive judges, his word, not mine, in over 100 cases, issuing injunctions time after time and time, his words, not mine, to block the Article 2 executive powers of a duly elected president of the United States. But I think, and of course we have the ridiculous decision of Judge Bozeman that planes ought to be turned back to aid vicious Venezuelan drug gang members. But an equally absurd TRO was issued by U.S. District Court Judge Brendan Herson in the P-Flag versus Donald Trump case. In that decision, Herson halted President Trump's January 28th executive order protecting children from chemical and surgical mutilation, which blocked taxpayer dollars from being used for sex change operations for children. This is an absurd and activist TRO, and the only reason such grisly procedures were ever covered by Medicaid is that President Obama's CMS decided they would be. There is no law passed by Congress that genital mutilation of children should be covered by Medicaid. So it stands to reason, to paraphrase Barack Obama, that what was done by the pen and the phone can be undone by the pen and the phone. But Judge Herson says no, he is above the law and above the Article 2 and the Constitution. So I believe we do indeed have a constitutional crisis. Mr. Speaker Gingrich, I agree with you that the No Rogue Rulings Act is a very good start. And I really encourage the Supreme Court to issue a ruling to make this very clear. Professor Shaw, in December 2024, Biden's Solicitor General Elizabeth Prelogar criticized the practice of nationwide injunctions, Then in 2022, or previously in 2022, Justice Elena Kagan criticized nationwide injunctions. In October 2023, speaking at NYU Law School, you criticized nationwide injunctions and what you called precision judge shopping, which seems to me is exactly what's being done against the executive actions of President Trump now. And then in February 2023, in an op-ed in the New York Times, you said that the U.S. Supreme Court was at the time, quote, a genuine threat to democracy. But fast forward to March of 2025, and you're here today exhibiting enormous deference to not Supreme Court justices, but district court judges ruling dozens of times against the president's executive powers. And you're saying, well, they're just doing their job. They're getting it right, and President Trump has it wrong. Whereas it was the other way just a couple short years ago. Ms. Shaw, this looks awfully political on your part. Your response?
Thanks for giving me the opportunity to respond. I mean, I think what I was discussing in the quote that you mentioned was the problem, which I think is a very real one, of single judge divisions where plaintiffs can guarantee with 100% certainty that they will draw a particular judge, like Judge Kaczmarek in Amarillo, Texas.
And isn't that what's going on right now?
Not a single one of the 46 rulings that have come down against the Trump administration have been filed in single judge districts. It's entirely different. So I am not standing here saying that there is never abuse of the universal injunction. Reform, I think, is perfectly appropriate, but that's an entirely different problem, and that's not what's being addressed in the legislation. That's on the table.
Was the TRO in PFLAG versus Donald Trump correctly issued? And if so, where in USC 42 of the Social Security Act as amended with Medicaid, where do you see an entitlement for Medicaid coverage of sex change operations in children?
Sir, I apologize. I'm not sure the reasoning of the opinion. Many of these opinions have come down either on First Amendment or equal protection grounds, the TROs. So I would have to take a look at the reasoning in the opinion. But a temporary pause, which is what these TROs are, where a judge thinks there's a serious constitutional flaw with an order issued by the president, I do think is appropriate.
Temporary pause, just like puberty blockers. I yield back.
Gentleman yields back. We now go to the gentleman from South Carolina, right down the row.
Thank you, Mr. Chairman. Mr. Larkin, in your testimony, you talked about the history of nationwide injunctions and how this has not always been the practice in the courts up until the 1960s, and we've seen an escalation of nationwide injunctions by district court judges. How would you characterize the emergence of nationwide injunctions since the 1960s and its effect on the judiciary?
There are two things to keep in mind. First, the 1960s saw a rise in what is called institutional reform litigation, an attempt not just to win a case for a particular client, a particular John or Jane Doe, but to establish a rule of law that could be used in the whole category of cases to which it could possibly be applied, and then in a lot of others as well. So if you're doing it in a state, for example, you're not going to say that your client was the only one affected by unconstitutional prison conditions. You're going to sue the entire State Department of Corrections. Because what you want is to have one judge reconfigure the number of people in rooms, how the rooms are laid out, all of that. And so what you had was you had judges who, in some cases, were trying to decide with hellish conditions that would have made Dante blanch, and try to figure out how to deal with that. And so it's not surprising that in some of those cases, there are different prisons. There were in Texas, Mississippi, Louisiana, we know them all, that were absolutely awful. And a judge under those circumstances is probably going to have to do more than just say, okay, well, you have to give this one client a better room. So what you saw was a development in this regard of judges expanding the reach of the relief that was being granted. That was part of it. Part of it was also
just sort of real quickly, just from a time perspective, do you think that part of this emergence of nationwide injunctions, particularly against the Trump administration now, I mean, the numbers are kind of shocking, is partly due to partisan nature of some judges on the bench?
Oh, I don't doubt that at all. I mean, if you take a look at the selection process, presidents tend to look for people who are going to rule in accordance with their views, whether you're on the right or the left, whether you're a Republican or a Democrat. I worked for Senator Orrin Hatch when he was the chair of the Judiciary Committee. And if he was the chair under Obama, you would see one type of judge being nominated. If he was the chair under George W. Bush, you'd see a different type of judge being nominated. Different ways of looking at it is common among people, and people become judges.
Speaker Gingrich, earlier you talked about, obviously, that your support of certain congressional actions that would correct or rectify the role of the courts in these nationwide injunctions, but you also talked a little bit about that the court can self-police itself. I think with Mr. Kiley, you went into at least one metric on how that could be done, but what are your thoughts generally on how the Chief Justice, who seemed to kind of brush aside criticism of the courts and just say, well, you could just go through the appellate process, how could the Chief Justice rein in his own court?
Well, I suspect that Mr. Larkin actually knows more about this than I do. But my impression is that the Supreme Court has rather strong capacity to instruct district courts in a broad range of procedures. And I think that were the Chief Justice to basically preempt Chairman Issa's bill and say, this is how we're now going to handle it. I mean, the argument in this hearing, as I understand it, is really pretty narrow. It is that with over 600 district court judges, you cannot have them each thinking they're an alternative president. And therefore, there has to be an alternative system. One system would be to block all nationwide rulings. Another system would be to have it appealed automatically to the Supreme Court. So a nationwide ruling immediately got a nationwide court looking at it and recognizing that the appeals process that the Supreme Court Chief Justice referred to is nonsense when you're talking about executive branch actions, because the length of time it takes to go through the appeals process is by itself destructive of the capacity to have what Hamilton called as an active chief executive. He said that the system will only work with an active chief executive. Well, you can't be an active chief executive if you have a whole bunch of Lilliputians tying you up. And this is a classic example of Gulliver and the local district judge who suddenly has blown themselves up in their own ego and decided, I too could be president, and I'll show you because I'm actually a superior president, because you have to obey me.
Right.
It's impossible to defend situations.
And in that circumstance, or I know I'm over time here briefly, but in that circumstance, you have 600 presidents of the United States. Thank you, Mr. Speaker. With that,
Thank you.
I yield back.
Gentleman from Wisconsin.
Yeah, I don't like being here today. It's a sad state of affairs because you don't like to have to clip the wings of the judiciary or say that sometimes we don't have to obey a judge's order, which is, I think, where this is leading. But we have a lot of judges who are reaching decisions that are just so completely out of line, and where a lot of these decisions are going to revolve around immigration and removing people. And the only reason this has become such a big issue is that we had a president who decided, to the degree which he could, he's not going to enforce the immigration laws of the country. So after you have completely irresponsible president and completely irresponsible judges, you wind up in the mess we are today. Now, just to clarify things, I'll ask, maybe Mr. Larkin, Speaker Gingrich. Obviously, the country's been around now under our current Constitution for about 230 years, what precedents from the early part of our country indicate that injunctions should not be beyond parties directly involved in litigation? In other words, when Abraham Lincoln went to law school, what would he have thought about these decisions?
Well, of course, Lincoln didn't go to law school.
You're right, I was going to correct myself.
He read the law.
You're right.
But look, I've been around long enough that I remember talking with Jefferson. And when I talked to Jefferson, he said, you simply can't have an oligarchy. And if you allow judges to be the final determinants, you by definition have left the people behind and established an oligarchy. I really think if you look at Lincoln, and if you read Fehrenbacher's extraordinarily detailed book on Dred Scott, Lincoln makes the Dred Scott decision the centerpiece of the 1858 campaign. And when Lincoln is very clear about this, think about Lincoln at Gettysburg, when he says government of the people, by the people and for the people. He's not only referring to Southern slave owners, he's referring to the court. And he's saying, by definition, you cannot usurp the right of the elected officials. Now, if you read the Federalist Papers, it's very clear that the Founding Fathers thought the weakest of the three branches would be the judiciary, that it would always be cautious because it would always be subject to being overwhelmed by the executive and legislative together. And in fact, you all represent the branch the Founding Fathers most feared because they assumed that the people elected by the people would have the greatest power. So we just have to recognize there's a...
And we said they were wise.
Yeah, that's right. Look,
Did
I
we
think there are good
ever-
reasons to fear the
Can I-
institution I once led.
Can I just add a short supplement to that?
Sure, I'd like to say, did this issue ever come up in the 1840s or 1850s or 1860s or 1870s?
No.
Okay, it was just assumed, it was understood at the time?
The law of equity was party-specific. If person one sued person two, the court would remedy whatever harm person one suffered. The court would not then go on and enter an injunction that tried to govern society. That was not the role of the courts. And the Supreme Court has even made that point more recently. They've said the responsibility to adjudicate a case of controversy is quite different from the responsibility to govern the society. The Lewis versus Casey, which is cited in one of my articles, makes this point. So it was not a component of equity in England or, as you put it, in the 1840s, 50s, or 60s. It happened only much later.
Okay, now we're never supposed to, they tell us you're never supposed to ask the Democrat witness, but I'll break with my stuff. Ms. Shaw, what do you think is the strongest example of a case, say, before 1870, in which a district court tried to come up with a ruling that affected the whole country?
We don't have examples that are of the sort of nationwide injunction that we know today. I don't think that's really in question. There's been an enormous increase. The scholarly debate about how kind of how historically grounded this is, goes back and forth, but it's either about a century old or a little more, but I don't think there's much suggestion that there were injunctions of this sort in the early
Okay, that would be an
19th century.
indication that under our Constitution, our forefathers never dreamed we'd have these type of rulings come from somebody who just, it comes from an individual district. But we'll ask, I could tell Speaker Gingrich wanted to get in one more swing here, so we'll let you get in the swing and then I'll.
Look, what we have seen over the long sweep of American history is a gradual, steady increase in the self-esteem and power of lawyers. Marbury versus Madison is totally misrepresented. The fact is that Marshall was terrified of Jefferson, knew that the Jeffersonians would gladly wipe out the court, danced around. It's not revisited until Dred Scott, and Dred Scott's a disaster. And so you really have a long period here where judges didn't think they had the power to define for the country how the country should behave. And what we're living through, and I'm very sympathetic to the agony on the left, because this is if you have Jefferson, Jackson, Lincoln, FDR, and Trump, this is the fifth great cycle of a profound challenge to the existing order. And obviously, these kind of periods are very painful, and they're very dangerous, and you got to work your way through them. And I think this is one of the examples. You have a group of people, well-meaning, I believe, but ideologically deeply convinced that they have the power to overrule the President of the United States. And now the country has to make a decision. Do we, in fact, have alternative presidents in the form of district judges or not? And the country, I think, will overwhelmingly decide that that's impossible. And so, but this is a classic historic, this is what the Congress should be about at its best. This is a classic historic discussion on both sides of how we retain a balance of power between the three branches. And I think that's where we are.
Thank you. We now go to the gentleman from Texas who's been patiently waiting.
Thank you, Mr. Chairman, and thank you to the witnesses who are here. We discussed it a little bit earlier, but I'd like to put a little bit of a finer point on it. In the 117th Congress, then Chairman Jerry Nadler, as well as Hank Johnson, introduced the Judiciary Act of 2021, which would have increased the size of the Supreme Court from 9 justices to 13. That bill had 59 Democrat co-sponsors, and they were so convicted that the size of the Supreme Court should be 13 justices that they then reintroduced the same bill in the following Congress and received 65 co-sponsors. So I am looking forward to my colleagues on the other side of the aisle reintroducing that bill this Congress as well. We hear a lot about bipartisanship, and I'm sure you can get a little bit of bipartisan support for that when you do. But with that said, Mr. Chairman, civilization is a very fragile thing. And in the Western world, particularly in the United States, it's been unraveling as the left and their allies in the courts have intentionally and deliberately facilitated the mass migration of criminal illegal aliens into our communities. These are people who are murdering and raping and pillaging American citizens on American soil. A country that was once the zenith of civilization, America, increasingly resembles the third world and is reverting to barbarism, as Ms. Romero's testimony so poignantly underscores. And instead of fighting for the preservation of our communities and the integrity of our nation's sovereignty, our colleagues on the other side of the aisle want to keep alien terrorists within our borders. And it's so many times district court judges are leading the charge. And I think that Judge Boasberg is an excellent example of that. Mr. Speaker, thank you very much for being here. It's an honor to be able to speak with you and ask you questions. I look up to you a lot. Could you explain how much constitutional and legal authority does Congress have to oversee lower courts?
Well, there's virtually, if it acts with the executive branch. I mean, the part of the theory of Montesquieu's spirit of the law, which is the base of the Constitution, is that you have these 3 bodies. Any 2 outvotes the other one. So in a very real sense, the Congress and the judiciary could take on the executive, or the judiciary and the executive could take on the Congress. There's a constant revolving. President Jackson made the argument that, in fact, each of us, every elected official, has an equal obligation to enforce the Constitution. And he refused to accept the idea that the court could instruct him. I mean, they very blatantly just said, glad you think that, I don't. And then Taney, who was his attorney general, who defended that, ends up as a Supreme Court justice, in many ways leading to the Civil War by his decision in Dred Scott. So I think you have every right, if you read the Constitution itself, you create lower courts. I mean, the Supreme Court is superior in the sense that it's the one thing in the Constitution you could not eliminate except by constitutional amendment. Mm-hmm. But everything below that is a creature of the legislative-executive agreement. I'm assuming here you're not going to try to override the president, but theoretically, the Congress could decide, and if it had the votes in the House and Senate, you can override a president.
Right.
So the courts are actually much more subject to the policing of the elected officials of the United States than they think they are, and that's because for about 3 generations now, law schools have taught this mythology of legal supremacy based on the judicial branch alone. It's nonsense. It's one of 3 co-equal branches, and it is the weakest of the 3, not the strongest.
In terms of enforcing that oversight, putting aside whether impeachment is the most expeditious or prudent means right now to oversee the courts, do you believe that it should be at least considered as an option to remedy blatant or flagrant judicial overreach from district court judges?
Well, I think that Chairman Issa has exactly the right first step. I mean, look, we're in the middle of such enormous change that this will strike some of you who know my career as sort of unusual. I'm actually now in a period of thinking incrementalism may be pretty good because we've actually set an enormous shift strategically. And now we need to spend a little bit of time cautiously, so I don't want to overreach, which you, theoretically, you could abolish the district judges. You have that power if the president agrees. But that would be an enormous jump. And I think the country needs to educate itself. And frankly, the judges are going to get educated. If they see the legislative branch seriously moving, it's one thing to have the president say something, from the bully pulpit. It's another thing to suddenly see laws moving and realize, if we don't pull back a little bit, this could become uncontrollable.
Yep.
I'm hoping, that's why today I've repeatedly talked about the opportunity the Chief Justice has, because I really hope he'll realize he has the best, easiest, least disruptive solution.
And for the record, I agree that I think that Mr. Isa's bill is an excellent piece of legislation that we should all be able to get behind.
As a freshman, you're going to go far. The gentleman from Washington is recognized for 5 minutes.
Thank you, Mr. Chair. Thank you to our distinguished panelists for this insightful testimony and what's been a long day. Mr. Speaker, it's a real honor to be able to ask you a few questions. When you're a freshman in this body, you see a lot of portraits on the wall, and frankly, you don't know who a lot of the people are, but I think the American people always remember you in the mark you've left on this institution. The question I have for you is just to comment on the situation the American people find themselves in, because I think this is a very dangerous and perilous time for America, because I think the American people think the fix is in. And you talk to the average person in my district, and they look at a situation where over 12 million people came into the country illegally, and there was no remedy to stop that procedurally from their elected officials. And now they look at a situation where after they had an election, they had a president that clearly campaigned on this issue, and they look at dangerous gang members who spread fentanyl that's killed over 100,000 Americans, more than died in Vietnam, more than died in the wars in Iraq and Afghanistan, and they say, well, let's get these people out of here. This is what we just voted for. And yet now there's a system where the one judge or a few judges in a certain area after judge shopping can stop. So they look at the situation and say, is there any remedy to this? What is the future of the republic if what they just voted for is something as egregious as dangerous, hardened gang members from a foreign country, in the country legal, spreading a deadly drug that is killing over 100,000 Americans, and they say, well, how is this supposed to work? So what would be your comment to these people?
Well, three quick things. First, I run a project called the America's New Majority Project. And if you ask the American people, do you think the system is corrupt? 82% say yes. Now that's really dangerous in a free society. I don't care what your ideology, what your partisanship is. When more than 8 out of every 10 of your fellow Americans think the system's corrupt, you have a deep challenge to somehow break through, really on a nonpartisan basis. Second, President Lincoln once said, with public sentiment, anything is possible. Without public sentiment, nothing is possible. And I think it's very important for every judge who thinks they want to impose themselves on the president to ask themselves, are you putting the entire judicial system in disrepute? Because if the country sees really sort of, by the standards of most Americans, fairly radical positions being taken by judges, blocking what is the clear will of the American people, not just the president, I think that it literally puts the entire underlying system under enormous stress and leads to popular dissatisfaction in a way that's very, very dangerous. The stability of the system ultimately requires that all of us find a way to work together, to behave in such a way that people no longer think the system's corrupt.
And Mr. Speaker, just finally, you referenced Thomas Jefferson, one of our founding fathers, one of the founding revolutionaries of this country, and the author of the Declaration of Independence, in your opening statement. I was able to visit the White House for the first time last week and got to meet President Trump there. And as we came in, we exchanged some pleasantries, and there was a kind of a humorous moment because neither of us knew quite what to do because staff wasn't telling us. And as we had this kind of moment of silence, and he said, well, can I show you the Declaration of Independence? And he turned around and it showed it to me that was on his wall, and he was very proud he just had it installed. And so it was kind of a fun moment, as you can imagine, for any American citizen, particularly a fresh member, a Congress. But I hear you loud and clear, and I hope on what you think is the best remedy at this point is that Chief Justice Roberts steps in and brings some clarity and some sanity to the craziness right now. But if he didn't, and President Jefferson were sitting in the White House or the president right now, what do you think President Jefferson would do if Chief Justice Roberts wouldn't step in and help this issue?
You know, the Jeffersonians as a group were bitterly anti-judge. The number 2 demand in the American Revolution, after no taxation without representation, was their hatred of the British judges, because they were appointed by the king, served at the king's convenience, and were seen as the oppressors imposing the law of a foreign government on the American people. And Jefferson had grown out of that tradition. Jefferson's probably the most radical of the founding fathers. And the Jeffersonians ran essentially on cleaning up the judiciary. This is why the whole thing with Marshall is such a wonderful example of a sleight of hand. Because if you look at the Judicial Act of in 1801, after they lose the election, the Federalists passed the Judiciary Act of 1801, which creates judges, many of whom were being appointed literally the night before Jefferson sworn in. So they were called the midnight judges. Well, the Jeffersonians thought, we're not going to have this. So they write the Judiciary Act of 1802, and they wipe out, as I said at the beginning of my statement, they wipe out, I think, 16 of them, 14 of which were actually occupied. I got into this because a good friend of mine who's a great lawyer said those must have been vacant because, after all, it's a lifetime appointment. No, we went back and pulled up the biographies. These 14 guys had to go out and get a job. I mean, they were gone. And so I think Marshall knew, you pushed Jefferson very hard. I mean, a guy who buys half a continent, sends the Marines to Tripoli, you really want to play this game? And they didn't. I mean, he was if you read Marbury versus Madison, it's a brilliantly clever device in which he says, we really have this authority, but you don't have to worry about it because we ain't going to give it to him. So, you know, Marbury doesn't get his writ. Well, so he tweaked Jefferson, but he knew if he tweaked him too much, he would probably have replaced the whole Supreme Court. I mean, the Jeffersonians were very tough about this stuff. I think Jefferson also was very practical. And I think what Jefferson would say is, you've raised the issue, you've begun to get the country aware. You might consider as a first step, Chairman Issa's bill, there may be, I'm not suggesting this, but I'm responding to your question. It may be speculatively at some point that the most radical and dumbest of the decisions could lead to interrogatories to the judges, first in writing. It might even be conceivable at some point that the judges might be brought in under oath to explain how did you think of this? What's the constitutional basis? Why are you doing this? I mean, there are many ways one could pursue this. My hope is that the comments we've made here today will in fact move the Chief Justice to eliminate the problem and to get back to a situation where no single district judge is an alternative president, and where we can have greater respect for the court system because the court system has greater respect for us.
I thank you all. It's been a long day, and although my closing statement I'll read in a moment says this will be in writing, just to make it easier for all of you, there are approximately 8,000 petitions to the Supreme Court every year. Over the last 3 calendar years, the court has accepted 68, 62, and 62 of them. We've heard a great deal today about just appeal, just go through, on now what's clearly going to hit over 100 national injunctions, all of whom would, according to Chief Justice Roberts, have to go to him through an appeal process. Even with Speaker Gingrich's suggestion, that would be 100 additional cases potentially in a year going to the Supreme Court. In writing, because it has been a long day, to the extent that any of you want to opine on the question of the burden to the court that comes from these many, many, many national injunctions, because we've talked about my bill here quite a bit today. We've also talked about impeachment quite a bit today, and you're all welcome to opine on that in written. But I think it's important that we also ask a lot of functional questions. Ranking Member Johnson and I, we oversee the courts. We've moved again in this Congress on a bipartisan basis, to add 66 new judges at the district level. But we all have to be concerned of caseload, of how do we get the right number of cases, how do we get them to the judges, how do we get good decisions, and ultimately the burden that flows up to the Supreme Court. So, as my script now says, this concludes our hearing, and I want to thank our witnesses, and I would ask that all members have 5 legislative days in which to give additional written materials for the witnesses, along with other material, and would ask that the witnesses be willing to respond to those if they receive them. And before I gavel, Ms. Romero, you weren't asked any questions to speak of today because you weren't a constitutional scholar, but I'll leave to you the last word.
I'm worried that all the outrage following the illegal immigrants' rights and their right to be here, and they could be good people, and we need to have them properly vetted before we get them out of the country. Where was all the outrage before you let them in? Where was all the outrage when my video happened? You guys save your outrage to when it's convenient to fight a president who's trying to make a positive change in the country. Where was all your outrage when I needed your help? Because I feel like you guys have lost the plot, and you're allowing harm to come to Americans in the pursuit of stopping President Trump. And I don't think that that's right, and I don't think that it's fair, and I don't think in the next election it'll stand.
Thank you.
Mr. Chairman.
We stand adjourned.